Hello, good morning, and welcome to Baiju's Exam Prep. Yesterday, we discussed Articles 14, 15, 16, and the introduction to Article 17. In Article 14, we spoke of what is the difference between equality before law and equal protection of the laws. One is a negative concept, the other is a positive concept. One is borrowed from England, the other is borrowed from United States. And the primary purpose is that we cannot be treating everyone equally because no two human beings are equal. Treating everybody equally would result in an unequal treatment. That is why, under equality before law, we say there are no special privileges no matter who you are. Everyone is subjected to the same set of laws that we have in India, and nobody is above the law. But it is this fundamental right, which also is not absolute because there are exceptions, such as the office of the president, the governor, the visiting heads, the diplomats of foreign countries. But when it comes to equal protection of the laws, it primarily means like should be treated alike. In a sense, those who are in similar situation should be treated similarly. Those who are in dissimilar situation, if they are treated equally, it would result in an unequal treatment. Progressive taxation is one such example. For example, the more income you have, the more taxes you will have to pay, and vice versa. Then we spoke of Article 15, which talks about that state shall not discriminate against its citizens only on the grounds of religion, race, caste, sex, place of birth. Which means if the state has to discriminate, there must exist other ground other than these five grounds mentioned in the Constitution. But even then, there are exceptions, such as the state has the power to make special provisions for women and children. There are exceptions, for example, those who are socially and educationally backward. Seats can be reserved for them in educational institutions. And we have discussed how this reservation in educational institutions got extended first for SCs and STs, then for OBCs, and then for the economically weaker sections of the society. Then we discussed Article 16, which primarily means that there shall be equality of opportunity in public employment. When the government is advertising posts, inviting applications for government jobs, everybody should be given equal opportunity to get this government job. And the state shall not discriminate only on the grounds of religion, race, caste, sex, place of birth, residence, descent. But on the grounds of domicile, there can be discrimination. On the grounds of language, there can be discrimination because you can impose language as a qualification to get a particular government job. On merit, there can be discrimination. On age, there can be discrimination. On medical grounds, there can be discrimination. But only on these seven grounds mentioned under Article 16, no. Then we discussed how reservation originally was planned for the members of SC and ST community, but then how, when the Mandal Commission was set up in the 1978, how this Mandal Commission recommended something known as the other backward classes other than SCs and STs, and how OBC reservation got implemented in India. Then we discussed the Indira Sani judgment, wherein the Supreme Court said OBC reservation is constitutional, subject to five requirements. Then there is reservation and promotion. Then we spoke of carry forward policy. Then we spoke of EWS reservation, whether that is good, bad, and the ugly. Then we discussed Article 17 of the Constitution, which talks about abolition of untouchability. And I told you this term, untouchability, is in quotes, which means we are not talking about the literal meaning of this term, untouchability. We are talking about the historic practice of untouchability, which was practiced in ancient India and unfortunately is being practiced even today. That is why we say there is a clash between constitutional objective and the reality. Objective is abolition of untouchability, but the reality is it is being practiced everywhere. But what should be the solution to this? That is something that we will discuss in social issues. Because in social issues, where we will discuss the society of India, we will look at the problems which are plaguing the society of India. One such problem is the caste conflict, the caste atrocities being committed in the name of caste. But this term untouchability, since it is in quotes, which means we are referring to the historic practice of untouchability, this is an absolute fundamental right. In a sense, there are no ifs and buts. In a sense, there are no exceptions that untouchability is abolished, but some individuals can practice it. Nobody. But what if somebody practices it? For that, we had a law known as Protection of Civil Rights Act 1955, which was considered to be weak, which was considered to be unable to fight untouchability. And that is why we needed a stringent law. We needed a tougher law. And that tougher law was passed in the year 1989, which is normally and commonly known as the Atrocities Act. According to untouchability, what constitutes untouchability? What are the examples that you can cite on the basis of which you can say that somebody is practicing untouchability? And I gave you a few examples yesterday. If you are refusing admission to any person, this person belongs to SC, this person belongs to ST. If you are refusing admission to them, whether in educational institutions or in public places or in government hospitals and dispensaries or even in private hospitals, this is something which is considered to be a practice of untouchability. Similarly, preventing any person from worshipping or offering prayers in any place of worship, this is a form of untouchability which is prohibited by the Constitution, and Constitution seeks to abolish this practice of untouchability. But to make it further clear, if somebody is insulting you because you are from SC or ST community, it is a form of untouchability. If somebody is not insulting you but is preaching others that we should practice untouchability, we should boycott these people, we should not buy groceries from these people, we should refuse admission to their children, we should not let them enter our temples, you're preaching it. Or if you are justifying it, all these are the forms of untouchability which is prohibited by the Constitution. And if you practice it, you will be booked under the Atrocities Act. And I told you this Atrocities Act is a very strong or stringent law in a sense that the burden of proof is on the accused. The example that I gave you, that if there are two individuals who fight, one of them is a member of SC or ST community. Even if, for example, this individual is responsible for this fight, this individual has instigated this fight, this individual has led this fight, but the courts will assume that this individual has initiated this individual has done this because this individual is practicing untouchability. And it is now for this individual to convince the court, to justify before the court that it was not because of her SC or ST status that this individual indulged in a fight, but it was of some other reason. It was because of some other reason. Because the burden of proof is on the accused. Similarly, we discussed that in 2015, significant amendments were made to this Atrocities Act, where more examples were added. And if somebody is indulging in these practices, we say this is a form of untouchability which is prohibited by the law. For example, tonsuring of head, whether you have witnessed it or not, in villages, a member of the SC community or ST community, their heads were shaved. to differentiate them from the members of the other community. Some of them were not allowed to even sport a mustache. Why? Because this is considered to be the sole prerogative of the members of the so-called upper castes. Some members of the Dalit community, they were garlanded with chappals. All these were examples, practices added to this law, and anybody practicing all these things would also constitute untouchability and would be booked under the Atrocities Act. There have also been individuals, particularly in the cities. So, untouchability is a practice which is not only practiced in the rural areas, even in urban areas, we see the form of untouchability rampant in our society. For example, those who manually clean our dirt, who manually clean the septic tanks and manholes. Who are these individuals? Almost 100% of them are the members of SC or ST community. So forcing their members to practice manual scavenging, to manually clean the dirt, this is also a form of untouchability and is prohibited by the law. But then something else happened. What happened? There was an allegation that this untouchability, that this Atrocities Act is misused, is abused, and is overused. Why? The reason was immediate arrest, no bail. What does that mean? I am a member of SC and ST community or ST community. You are an individual. The example that I gave you, that I owe you the money. Now you are asking, please give me my money back. I'm refusing, and instead I'm fighting with you. Ultimately, what happens? You will punch me, or you will keep on pestering me, give me my money back, give me my money back. Now I'm refusing. I will not give you the money. And if you come to my house again, I will book you under the Atrocities Act. I will go to the police. Dear police, please file an FIR. Why? This is the case of an Atrocities Act. Why? Because this person is insulting me because of my SC status, because of my ST status. And the police has to register this FIR. And once this FIR is registered, you are immediately arrested. Once you are immediately arrested, even this process becomes punishment. We say the arc of justice is long, but it bends towards justice. It bends towards equality later on. This process, when you are arrested, immediately arrested, and you spend a lot of time in the jail, even this process becomes punishment. At the end of the day, once the trial is over, you will be able to convince the court will set you free, now you're innocent, but you may have lost 1, 2, 3, 4, 5, 6 years of your precious life. You may have lost the prime of your youth because you were booked under a false law, under a false complaint. When there is immediate arrest, even if you apply for bail in the sense, you are arrested for a particular case, but the case will take a lot of time to be resolved, to be solved. The golden rule of criminal justice system is you are innocent until proven otherwise. That means unless and until you prove yourself or the prosecution proves you that you are guilty, till then we will assume that you are innocent. Which means you don't have to necessarily remain in jail, because what if you are innocent? You will lose a lot of your time in the jail. We will release you. You will be out on bail. But at any point in time, police may call you. At any point in time, the court will call you, and you have to cooperate with the police because the police will conduct investigation. So, golden rule of criminal justice system is you are innocent until proven otherwise. But in Atrocities Act, it is reverse. You are guilty unless and until you prove that you are innocent, which means we will not release you on bail. It's very difficult to get a bail under the Atrocities Act. and people have been languishing in jail for years and years together, and some people say also under false cases. Matter went to the court. The Supreme Court said we have to somehow prevent the misuse of this law because the law is being misused. Now, there are certain guidelines that we will mention. Subhash Mahajan, the Supreme Court gave its verdict in August 2018. The Supreme Court said no immediate or automatic registration of FIR or arrest. Previously, what would happen? The moment I file a case under the Atrocities Act, ultimately what will happen? The police will come and arrest you. Automatic registration of FIR leading to arrest. This will not happen now. Now, what will happen? When I file this complaint before the police will have to conduct preliminary inquiry. The police will have to conduct a preliminary inquiry in the sense, you come here, you also come here. What is the fight between the two of you? Sir, he assaulted me because of my SC/ST status. No, sir, I gave him money. He owes me money, but he's not repaying that money. Show me the proof. Sir, this is the proof. These are the WhatsApp messages. These are the transactions. He told me last night that I will pay you the money. You come to my house. I went to his house to collect the money, but he says he came to my house to assault me. After this preliminary inquiry, the police, if it feels that no, this is not a case of atrocity, this is not a case under the Atrocities Act, you will not arrest this individual. And if you think that yes, this is a case of atrocity, you will have to take the written permission of the DSP or an SP before you can make the arrest. Why? Because DSP and SP, they are at a higher position in the police department. They will logically apply their mind. You may not expect a constable or a havaldar to apply his mind because of lesser educational qualification or because of lesser exposure, whatever it is. So the assumption is that the SP, DSP with better educational qualification, with a rational mind, they would be able to apply their mind better and decide whether to arrest this individual or not. But once this verdict was given by the Supreme Court, there was a series of protests in different parts of the country. The allegation was that Supreme Court has diluted the law and deterrent effect of the law would disappear. Allegation was that because of the Supreme Court verdict, now there will be no deterrent effect of this law. Because previously I would hesitate in indulging in a fight with a member of SC or ST community. I would hesitate in insulting them, preaching untouchability, justifying untouchability, because the law was so tough, I could be easily arrested, immediately arrested. But now when the Supreme Court is saying no immediate arrest, now I will justify untouchability, preach untouchability, practice untouchability, because I know I will not be immediately arrested. There were a series of protests. In fact, some people got killed in these protests as well. The protesters were asked, why do you think you are protesting? Why do you think the Supreme Court verdict is wrong? Because the Supreme Court was presented with that data. It's not that Supreme Court randomly said that the law is being misused, overused, hyperused, abused. That is why we need to tweak the law. We need to change the law. No, the Supreme Court was given data. According to this data, number of police complaints and number of convictions, number of acquittals. How Supreme Court came to this conclusion that the law is being overused, misused, overused, abused, hyperused? The Supreme Court was given data. Supreme Court asked for the data. Across the country, gave us the number of cases filed under the Atrocities Act. Said this is the number. Out of this number, tell us how many people got convicted. So the percentage is less than 3. That means how many people got acquitted? Sir, more than 90%. Which means more than 90% of the cases were false. That was the assumption of the court, that more than 90% cases were false, which means that the law is being misused, overused, abused, hyperused. But the Supreme Court missed something. Supreme Court, listen to me carefully. Supreme Court was presented with a data on the number of police complaints filed in different police stations in India. But do you know what? There are lakhs of cases. If not lakhs, there are thousands of cases which the police does not register. No registration of cases because of caste bias. That means when atrocity is being committed against SC or ST community, they approach the police. The police inspector, the Thana officer belongs to the member of the upper caste. They show these complaints away, saying, no, we will not register this complaint. Do whatever you have to do. And these poor people, they have no other option but to go back, because they lack resources to approach the judiciary. They lack the voice through which they can amplify their protests, because Arnab Goswami will not listen to them. Be that as it may, so if the courts came to the conclusion, because the court was presented with the data on the number of cases filed leading to the number of acquittals, which means more and more people were acquitted, which means more and more false cases were filed. But the Supreme Court missed an important thing. Maybe the cases do not reach the police. Initially, I would approach the police, please register the FIR. They are not registering the FIR because they are biased against my caste. Ultimately, what will happen? I will stop approaching the police. That doesn't mean atrocity is not ending. And if you would have read yesterday's newspaper, a minister in Puducherry government resigned, alleging gender as well as the caste bias, saying, I thought people have evolved. I thought some members of my community, they have done well in politics and I can do that as well. But I am being suffocated, and that is how I am tendering my resignation. So caste atrocity is a reality. And when this judgment was given, when there was series of protests, ultimately the government decided to amend the law, the Atrocities Act. The government amended the law, added section 18 capital A to the act, which restored the status quo ante. Status quo ante in the sense, what did this judgment say? Subhash Mahajan case, that no automatic immediate arrest or FIR, preliminary inquiry, written permission from the DSP or the SP before making the arrest. By adding section 18 capital A, the Supreme Court restored the status quo ante, which means what was the position of this law before this judgment? The same position continues. What was the position before this judgment? Immediate arrest, immediate registration of FIR, no need for a preliminary inquiry, no bail as well, no requirement for a written permission from DSP or SP. The same position continues now as well. Why? Because by adding section 18 capital A, the law specifically talks about that there is no need for any preliminary inquiry. There is no need to take the permission of the DSP or the SP, and there is an immediate arrest under the Atrocities Act. So basically, through this amendment, government got the parliament to amend the law and ultimately restored the same position as it existed before this judgment. And when you restore the same position as it existed before, that is what we call status quo ante. Even this amendment was challenged before the court. The court was told, my lord, look what has happened. Said, what has happened? Sir, you gave a judgment in Subhash Mahajan case. You know what the parliament has done? What? Parliament has nullified your judgment. You said no immediate arrest. They are saying immediate arrest. You are saying need for a preliminary inquiry. They are saying no need of a preliminary inquiry. You are saying take the permission of the DSP or the SP before making the arrest. They are saying no such requirement is required. Now, a three-judge bench of the Supreme Court in October 2019 declared that yes, this amendment is constitutional. Yes, this law which has been amended to nullify this judgment, it is constitutional, which means now the position remains the same as it existed before. Immediate arrest, immediate registration of FIR, no need for a preliminary inquiry, and no requirement of a written permission from the DSP or the SP before making any arrest. That is Article 17 of the Constitution. Any questions? Let me know. Even Prevention of Money Laundering Act has such similar strict provisions. Yes, there also you are guilty unless and until you prove otherwise. What if the situation exists between two SC or ST people? This law will not apply. But sir, is the High Court in exceptional circumstances has the power to grant bails? Yes. Court in October 2019 said High Court retains the power to grant bail in extraordinary cases. That is true. Because high courts generally, in any case, in extraordinary circumstances, they can grant bail. Sir, any other example of status quo ante? 2016, Arunachal Pradesh government was dismissed. President's rule was imposed in Arunachal Pradesh. Clear? And then when the president's rule was imposed, then a new chief minister was appointed, a new government was in place. But the previous chief minister challenged this imposition of president's rule in the court. And once the final judgment came, there was already a different chief minister. Final judgment said imposition of this president's rule is unconstitutional. It was done improperly, wrongly. The Supreme Court restored status quo ante, which means what was the situation when the president's rule was imposed? We had a different chief minister, Nabam Tuki. The same chief minister was reinstated. That is what we call status quo ante. No, my dear, I do not teach PSIR optional. Now let's look at the last article under the category right to equality, Article 18, which talks about abolition of titles. What is a title? Title is something that is given to you not necessarily because of your educational qualification, not necessarily because of your exceptional contribution to the society. Title may be given for sycophancy as well. For example, during British times, titles were given such as Sir, Rai Bahadur. In fact, there is a case where Raja Digvijay Singh of Balrampur, he was nominated to the Legislative Council, but he was illiterate. A friend of his asked him, how do you decide whether to vote in favor of this bill or against this bill? How do you decide this? Because you can't read and write. He says, I look at the viceroy. When the viceroy raises his hand, I also raise my hand. When viceroy lowers his hand, I also lower my hand. Which primarily means that during British rule, to propagate this British rule, to ensure that this British rule continues, what do you need? You also need to cultivate loyalty of the local people, because without their loyalty, you may not be able to sustain your rule. That is why when a massive revolt broke out in the northern and central part of India in 1857, it nearly swept away the British rule. For more than 2 years or close to 2 years, the artisans, the laborers, they fought heroically and through their sacrifice wrote a glorious chapter in India's struggle for freedom. But this revolt of 1857 was crushed by the British. How? With the support of the local people. Intelligentsia. They did not support those who started this revolt. They thought that these are the people who are with old mindset. They will take us back to the old ages. We should support the British because through their scientific temper, they can usher in a period of development in India. They will make India also a mirror image of Britain. So the intelligentsia supported the British. The capitalists supported the British. The local rulers of the princely states supported the British. The zamindar supported the British. That means unless and until you cultivate the loyalty of the local population, you will not be able to propagate and sustain your rule. And how Britain would reward these loyalists? By giving them titles. Sir, Rai Bahadur, ultimately creating a wedge in the society, creating classes in the society, which is not equality. For example, in 1885, one organization was established. What was the name of that organization? Indian National Congress. But the same year, another organization was established, UPA, United Patriotic Association. This was led by Sayyid Ali Khan. And there was another Raja from Banaras who was associated with this United Patriotic Association, Raja Shiv Prasad from Banaras. And how did the Britain reward Sayyid Ali Khan? By awarding him the title of Sir Sayyid Ali Khan. Which primarily means that titles were awarded basis the loyalty that you want to cultivate, creating classes in the society. But once the constitution was enacted, when we spoke of the concept of equality in the constitution, Supreme Court said, the constitution said, the Constituent Assembly said, there can be no titles awarded by the state. So Article 18, Clause 1, it says no title shall be conferred by the state, except title can be academic, title can be military. Chief of Defense Staff, it's a military title. Lieutenant Colonel, it's a military title. Major, Admiral, Chief of Staff, Doctor, Engineer, Professor, all these are either academic titles or military titles. Such titles can be awarded by the state. But except them, no other title can be awarded. 1954, Padma Awards were constituted. Padma Awards, Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. These awards were constituted. So Bharat Ratna, which was given, which is the highest civilian award in India, maximum 3 per year. That means it's not necessary for the government to award Bharat Ratna every year. But whenever they award, maximum they can award 3 persons in a particular year. Then we have other civilian awards such as Padma Vibhushan, Padma Bhushan, Padma Shri. These awards were instituted. Bharat Ratna, which is the highest civilian award, it became such an award that Pandit Nehru recommended himself for the Bharat Ratna and got the award from the President of India. Indira Gandhi recommended herself for Bharat Ratna. In fact, majority of the awardees of the Bharat Ratna, the recipients of the Bharat Ratna, they are the politicians. Somebody like M.S. Swaminathan, who recently passed away, the individual responsible for Green Revolution in India, he was not awarded. Sam Manekshaw, who played a stellar role in different wars in India, was not awarded. Sachin Tendulkar, on the date of his retirement, was awarded the Bharat Ratna, whether justified or unjustified, but on the date of his retirement, just to please him. The matter during emergency, when these titles, when these awards were given for political considerations in the sense, once Anupam Kher, a terrific Bollywood actor, fantastic actor, no doubt about that. He was asked, what is your take on these Padma Awards? He said, these awards are useless, foolish awards. They're given for the chamchas of the government. They're given for the sycophants. I reject these awards. They are of no value whatsoever. This was when the Congress was in power. And when BJP came to power under Mr. Modi's government, he was awarded Padma Shri. And he was asked, what is your take? How do you feel? He said, I am delighted to receive the most honorable award constituted and instituted by the government of India. This is the stellar example of the hard work, the honesty of the government with which I'm being awarded. But be that as it may, matter went to the court. Balaji Raghavan versus Union of India. The principal question before the court was that these Padma Awards, they are titles. Within the meaning of Article 18. Because we use them as titles. Bharat Ratna Atal Bihari Vajpayee, Padma Shri Anupam Kher, Padma Vibhushan Sri Ravi Shankar, so on and so forth. Baba Ramdev was also, there were reports that he was awarded Padma Bhushan or Padma Vibhushan. He said, no, I don't need this. Why, Babaji? You don't need this? Do you reject all these awards? Yes, you are a yogi, you are a sannyasi. He said, no, I needed Bharat Ratna. And then you use them as titles. Bharat Ratna ABC, Padma Vibhushan ABC, Padma Shri ABC. Ultimately, matter went to the court. The court was asked, is this not title within the meaning of Article 18? Because Article 18 says no title except an academic title and a military title. No other title can be conferred by the state. The Supreme Court said no. These Padma Awards, they are not titles within the meaning of Article 18 because merit should be recognized. Merit has to be recognized. So this Padma Vibhushan, Padma Bhushan, these Padma Awards, they are awarded on the basis of the merit. So you can't deny that these people are meritorious people, such as Kangna Ranaut, who got Padma Shri. So talented individuals being awarded, merit being recognized, that doesn't mean these are titles. But if you use them as titles, that is problematic. Don't use them as titles. Otherwise, we may deprive you of your title. We may deprive you of this award. So don't use them as titles, but there is no problem with these Padma Awards. So Article 18, which talks about abolition of titles, such as Sir, such as Rai Bahadur, which was propagated during the British rule. Article 18, Clause 1 says no such title can be conferred by the state other than academic or military title. But I can expect a question, although I think no student has asked it yet. Sir, why do we call Ravindra Jadeja as Sir Ravindra Jadeja? Why do we call Sachin Tendulkar Master Blaster? Why do we call Rajnikant as the megastar or superstar? Or why do we call Shah Rukh Khan as the King Khan? These are also titles. But we call Ravindra Jadeja as Sir Ravindra Jadeja. But is that title given by the state under Article 12? MS Dhoni referred to him as Sir Ravindra Jadeja, and after that, this name got stuck to him, Sir Jadeja. But this title, Sir, was not conferred by the state. Clear? And at the same time, if the fans are calling their idols as superstars or megastars or blockbuster stars or King Khans or Thalavi, whatever, that is basically the love given by the fans. That is not the title conferred by the state. If the state would have called Shah Rukh Khan King Khan, from now onwards you will be referred to as King Khan. That would be unconstitutional under Article 18. Article 18 Clause 2 says, no citizen shall accept any title from any foreign state. For example, Sunil Gavaskar. He was the first batsman to score 10,000 test runs. A prolific batsman. And he was all set to be knighted by the Queen of England. Because the Queen still, or the King still awards titles to people. For example, Sir Ian Botham, Sir Richard Hadley, Sir Donald Bradman, Sir Salman Rushdie, Sir Vivian Richards. All these are titles still conferred by the King or the Queen of England. Sunil Gavaskar may have been known as Sir Sunil Gavaskar. So he was very happy. He will be knighted by the Queen. Knighthood will be conferred on him. He will now be called as Sir Sunil Gavaskar. Dress, attire to travel to London and get this knighthood, but somebody told him, Gavaskar, what? You can't take this title. Why? Look at Article 18 Clause 2. What is mentioned there? No citizen shall accept any title from any foreign state. Said, holy God. That means I can't accept this title from the foreign country? No, you can't. Neither can the state award any title except academic or military, nor can a citizen accept title from any foreign state. That's Article 18 Clause 2. Article 18 Clause 3, there may be foreigners working in India as well. For example, there are lots of foreigners who are working in government in advisory capacity, advising the government on metro, advising the government on various other projects. That means these individuals are basically foreigners. For them also there is a condition. No person who is not a citizen of India, that means a foreigner, who holds any office of profit or trust under the state, who is now holding one position, advising the government on important matters, can this individual accept title from any foreign state? Yes, but first you have to take the consent of the President of India, which basically means you have to take the consent of the central government. So I am a foreigner advising the government on important matters. Now the foreign country is telling me that we will award you, or England is telling me that we will give you knighthood. I have to first seek the consent from the president. Can I accept this title from the foreign country? If the president says yes, I can go and accept this title. Article 18 Clause 4 says, no person holding any office of profit or trust under the state, which means government employees, which means the ministers, the judges, bureaucrats, without the President of India's consent, they cannot accept any present, emolument, office of any kind from a foreign state. You're going to become an IAS officer or an IPS officer or an IFS officer. As an IFS officer, you are posted in Germany, and the German state is telling you that we will gift you a house. You have to take the permission of the central government. You have to take the permission of the president. Without that, you cannot accept this gift. Because what if, in lieu of this gift, in exchange of this gift, you will exchange some important documents with them? That is Article 18 of the Constitution. So, Article 18 talks about abolition of titles. Titles, the way they were awarded during the colonial period, no such title can be awarded, can be conferred by the state, except academic titles and military titles. And no citizen can accept title from a foreign state under any circumstance. But if there is a foreigner working in India under the government, advising the government, then such an individual has to seek the permission of the President of India before accepting title from a foreign country. And if you're a government employee, you cannot accept even a gift, even a present, anything from the foreign country without the consent of the President of India. That is Article 18 of the Constitution. Any questions? Let me know. Sir, one doubt. Awards and titles given by other countries to our Prime Minister, will it not come under titles? Those are not titles, those are awards. So the highest civilian award of Saudi Arabia, the highest civilian award of Qatar given to Prime Minister Modi, it is an award. It's not a title. So title is something that you can attach to your name. For example, Dilip Kumar was given Pakistan's highest civilian award, Nishane-e-Imtiaz. But that is an award, that's not a title. If it was a title, then Dilip Kumar would have called himself Nishane-e-Imtiaz Dilip Kumar. Title is something that adds to your name. Award is not. Is sir a title? Yes, sir is a title. But not sir, Sarmad sir. If it was Sir Sarmad, then it's a title. And that sir should have been conferred by the Queen or the King of Britain. Why government is calling Gandhi as Mahatma Gandhi? There is, let's say, father of nation. Is that a title? It appears it's a title. Father of nation, Mahatma Gandhi. There was an RT application which asked for data response as to what is the official communication which calls Mahatma Gandhi as the father of the nation. The reply was that we don't have any such record. The government has not issued an official communication or an official order declaring Mahatma Gandhi as the father of the nation. It was during the Second World War when International Army led by Subhash Chandra Bose, they were on an important mission. On a radio broadcast, he sought the blessings of Mr. Gandhi and he called him, "Oh, father of the nation, we need your blessings." And that's how this got stuck with Mr. Gandhi. But this is a pre-constitutional development. We have to look at what happened after 1950. For example, Visvesvarya was awarded title by British, Sir Visvesvarya. We still call him Sir. Why? Because this is a pre-constitutional development. Happened before the commencement of the Constitution. Constitution talks about what happens now. Now titles cannot be awarded. In fact, Mahatma there is a different story to that. Mahatma Gandhi and Rabindranath Tagore, they gave each other titles. Said, I'll give you something. You'll have to give me something in return. Said, what? I'll call you Mahatma. What would you call me? I'll call you Gurudev. Thank you. Gurudev Mahatma. That's how these titles were given. Sir, why common people are not awarded these awards? Because they are common. Do something uncommon, spectacular, and you will be awarded. Is IAS a title under Article 18? Gunjan, sometimes you'll have to apply your common sense. If IAS was a title, it would not have been awarded, which means it's not a title under Article 18. Sir, if we use Bharat Ratna as title, is it a punishable offense? It's not a punishable offense. Even if you use it, nothing will happen. IAS, IPS is an academic title. It's not an academic title either. It's a post. It's a job. Miss World, what about these beauty titles? These are beautiful. These are not titles. These are awards given to you for some consideration. And in fact, this is not awarded by the state. So it's not Government of India is awarding Sushmita Sen as Miss Universe. It's a different pageant concept altogether. Why do judges use title justice? Why do doctors use doctor? Because doctors treat. And chief justices, they impart justice. That's their job. Sir, what's the eligibility of Bharat Ratna? Exceptional service in any field. That is the qualification eligibility for Bharat Ratna. And not necessarily Indians, even foreigners have been awarded Bharat Ratna. Sir, if there is no punishment, then why Sunil Gavaskar hesitated? That's for him to answer. If he would have asked my suggestion, I would have advised him go collect this title. Then let's see what happens. Okay. Jalak, what's your question, please? One more minute and we will start. Sir, who all are the foreigners awarded with Bharat Ratna? That won't be asked in the exam, but Nelson Mandela, Khan Abdul Ghaffar Khan, these were the individuals, foreigners awarded Bharat Ratna. Sir, can I use Sir President Raj of my upcoming son name? I can't decide the name of your son in this class. You're free to choose any name. Any examples of academic titles? Doctor, engineer, professor. If foreigners can be awarded Bharat Ratna, then why Indians can't accept foreign titles? Because Bharat Ratna is not a title. It's an award given for your exceptional contribution in any field. Okay. Now let's look at another category of fundamental rights, right to freedom, where we will have to discuss four articles, Article 19, 20, 21, and 22. Let's first look at Article 19. And Article 19 talks about protection of certain rights regarding freedom of speech. And all these rights, we say, are natural rights. Natural rights which occur naturally to an individual by the accident of birth. For example, it occurs naturally to you that after you're born, after some time, you're able to speak and express yourself. Freedom of speech and expression. It occurs naturally to you that you form friendship, associations, unions. It occurs naturally to you that you start moving, you start residing somewhere. So, all these rights under Article 19, we call them natural rights because they occur naturally to an individual because of the birth. And Article 19 is exclusively available to citizens. Just like Article 15, Article 16, which are exclusively available to citizens, Article 19 is also exclusively available to the citizens. And Article 19 talks about all these rights, such as Article 19(1)(a), that's how you write it, Article 19(1)(a), Article 19(1)(b), C, D, E, F was omitted, it was repealed, it was deleted due to 44th Constitutional Amendment Act 1978. Why it was deleted, we will discuss it later under Directive Principles of State Policy. But all these are fundamental rights under Article 19, available exclusively to the citizens of India, and we call them natural rights because they occur naturally to an individual because of the accident of birth. But we will first focus on Article 19(1)(a), then we will look at one by one other fundamental rights. But we will focus our utmost attention on Article 19(1)(a), which talks about freedom of speech and expression, but because this is the most important fundamental right, and it is almost always in the news and becomes very important for your examination. Let's look at Article 19(1)(a), freedom of speech and expression. For democracy to function, what do we need? We need freedom of speech and expression. Why? Because what is democracy? If we can look at one basic definition of democracy given by Abraham Lincoln, democracy is government by the people, of the people, for the people. Right? But how do we tell the people, how do I, as a candidate contesting the election, tell the people that you should vote for me? I'm telling you, you vote for me because I will not ask for votes in the name of religion or caste or language or region. I will not ask for votes in the name of mandir or masjid. I will ask for votes because if you vote for me, I will spend 10% of our GDP on education. I will spend 10% of our GDP on healthcare so that we have top class healthcare facilities, hospitals, dispensaries in India. Give vote for me and I will take this country in this direction. We'll spend more and more on creating job opportunities so that this demographic dividend that we have, it doesn't turn into a demographic nightmare. But what if the government stops me from saying these words? No, you can't do that. Will democracy sustain in India? Political education is very important. I have to tell the people of my constituency that you should raise your voice. If there is a polluter, if there is a factory which is being developed and set up in your state or in part of your state, and it is going to pollute your atmosphere, it is going to cause cancer for those who are in the vicinity of that factory, I have to tell them that you should raise your voice and approach the Supreme Court because Supreme Court will protect your fundamental rights. What am I doing? I am imparting political education to the people. What if the government says you can't use this language? Will democracy be possible in India? What if I am not allowed to say that don't vote for this particular government because this particular government has not spent enough on education? has not spent enough on healthcare. Not this particular government, any government for that matter. What if I'm not allowed to use this language? Will political education be possible? No. That's what former Chief Justice of India, Patanjali Sastry, said. Freedom of speech lies at the foundation of all democratic organizations. Because without free political discussion, no public education is possible. No public education, which is so essential for the popular functioning of the popular government, is possible. I should be able to criticize the government the way they're spending the money. I should be able to criticize the government for the way they're handling foreign policy or the way they're handling the protests in India. Whatever. Not just this government, previous government, next government, any government for that matter. And that's the right that we have as citizens. But if you're not allowed to say anything, how can democracies survive and flourish? How can public education be possible? That is why Constitution gives us a fundamental right known as freedom of speech and expression. And under this article, freedom of speech and expression, that means every single citizen of India who has a fundamental right under Article 19, say whatever you want to say, express whatever you want to express, write whatever you want to express. That is your fundamental right. And we say this Article 19(1)(a) is the second most evolved fundamental right. Evolved fundamental right in the sense, we will come across another term known as inferred rights. And what is that inferred right? Supreme Court is the final interpreter of the Constitution. That we all know, because what is Constitution after all? Is how it is interpreted by the Supreme Court. Supreme Court is the final interpreter of the Constitution. And when matters reach the Supreme Court, what Supreme Court does, Supreme Court looks at a particular fundamental right and starts inferring something else as well. When it starts inferring something else as well, it gives us those rights not originally mentioned in the Constitution. What does that mean? Mr. Naveen Jindal, he was a politician, he's still a politician, he belonged to the Congress party. He was in fact the MP of Lok Sabha from Haryana as well. A member of the Jindal family as well, who have business interests. He wanted to fly national flag at the top of his house, private house. He wanted to wear the badge of the national flag close to his heart. But he encountered a problem in the form of Flag Code of India. Because national flag is our national honor. The government gets to decide how do you use this national flag. For that we have a code known as the Flag Code of India. According to this code, this national flag then, according to this code then, when Naveen Jindal wanted to do this national flag could be hoisted only at the top of the government building, not the private building. That too on Republic Day, Independence Day, and other important functions, not every day. And you cannot use the badge of this national flag as a badge on your heart, because that is something which is violative of flag code of India. Mr. Naveen Jindal approached the court, said, "My lord, do I have the freedom of speech and expression?" Said, "Yes, you have. Under Article 19(1)(a), you are the citizen of India." "My lord, I want to express my love for my country." Said, "Yes, you can do that, but how do you want to do that?" "I want to fly the national flag at the top of my house. I want to wear the national flag as the badge close to my heart. That's how I want to express my love for my country. But Flag Code of India prohibits me from doing that." Supreme Court said, "No worries. This flying of a national flag is the symbol of expression. This is your fundamental right under Article 19(1)(a). Which means when we look at Article 19(1)(a), it only says freedom of speech and expression, nothing else. But who is the Supreme Court? Final interpreter of the Constitution. What Supreme Court does, interprets the Constitution. What Supreme Court does, looks at this particular article and infers something else as well, derives something else as well, and says flying of a national flag is also a symbol of expression. It is your fundamental right, which means it becomes an inferred right. You're inferring this from freedom of speech and expression. Something else happened. ADR, Association for Democratic Reforms, a non-governmental organization, an NGO, which is working in the field of electoral reforms in India, it petitioned the Supreme Court. "Supreme Court, do I have the freedom of speech and expression?" Said, "Yes, you are the citizen of India. You have the freedom of speech and expression." So not me specifically, not as an entity, as an NGO, but citizens, do they have freedom of speech and expression? Said, "Yes, that's what I told you. Freedom of speech and expression is available to every citizen." Yes, but what's the question? Sir, if I have freedom of speech and expression as the citizen of India, does that also include the freedom, the right to ask questions? Yes, freedom of speech means say whatever you want to say. And if you want to ask a question, that is part of freedom of speech. But yes, but what sort of questions do you want to ask? Sir, there are candidates contesting elections. Okay. We want people to have the right to ask them questions. Sir, what sort of questions? What is your educational qualification? What is the amount of property, assets in your name? In the name of your spouse? Criminal cases pending? So on and so forth. We need to ask these questions to these candidates contesting elections. But the Supreme Court asked, why do you want to ask these questions to the candidates? Association of Democratic Reform said, to ensure that citizens make an informed choice. You have to make a choice. For example, you want to marry this boy or this boy. How can you randomly decide whether to marry this person or the other person? You can't say 1, 2, 3, 4, 5, 6, this person is going to be my husband or spouse. You can't be doing this random thing. You need some information. so that you can judge both these individuals and ultimately decide who is going to be the best partner for your life. For example, similarly, we have to choose our candidate to represent my constituency. How do I randomly decide who is the best candidate I can vote for, who can represent me? I need some information on that individual. Then I can make an informed choice. That means I can make a choice basis that information. So if there are these candidates, 10 candidates contesting the election, what is their educational qualification? How many criminal cases are pending against them? What is the amount of assets in your name as well as in the name of your spouse? And when you will see that since the elections to the 5 states have been announced now, you will see that Indian Express would carry a detailed page where every day the assets of a candidate contesting elections would be displayed. Not just assets this year, but assets 5 years ago as well. So that people can compare. When I voted for him last year, his assets were 1 crore. But now when I'm voting for him, he's doing his wedding at Udaipur. Aam Aadmi. Despite claiming that in his affidavit that he does not possess property with this much as the annual income, people will question. So that basis that information, people can make an informed choice as to who is the best candidate to represent their constituency. Supreme Court said this right of information, particularly a voter's right to check, to know the antecedents, the assets of a candidate contesting election, this is your fundamental right. Article 19(1)(a) was an innocent looking article. Freedom of speech and expression. Say whatever you want to say, express whatever you want to express. That is your fundamental right. But now Supreme Court has expanded the scope of Article 19. And this is what we call judicial creativity. Judiciary, through its creativity, is expanding the scope of fundamental rights and giving us those fundamental rights which were originally not conceptualized by the Constitution, giving us other inferred rights as well. In another instance, Supreme Court said, if you have right to freedom of speech and expression, you have the right to remain silent as well. Right to speech means right to silence as well. That is also your fundamental right. So one by one, various rights were given under freedom of speech and expression, which makes Article 19(1)(a) second most evolved fundamental right. Sir, what is the second most evolved fundamental right? This is the article, this is the fundamental right under which second highest number of inferred rights have been conferred by the Supreme Court. Which is the most evolved fundamental right? Anyone? Article 21 of the Constitution, under which the highest number of inferred rights have been conferred by the Supreme Court. But when we say freedom of speech and expression, freedom to say whatever you want to say, in Bill of Rights in US Constitution, freedom of press is mentioned explicitly. In Bill of Rights in US Constitution, freedom of press. That means if you have the freedom of speech and expression as an individual, can you express the views and thoughts of others as well? How? Through newspapers. Freedom of press, the right of press, and press includes media as well. Arnab Goswami also has the right to call everybody at 9 o'clock in the evening and say, the nation wants to know. But nation told me, I never asked Arnab Goswami to ask questions on my behalf. Who is this nation who is so angry every night at 9? But be that as it may, freedom of press, which includes freedom of media, freedom of news channels to publish content without any censorship, that is also a fundamental right. Supreme Court said, so what, it is not mentioned in the Constitution. So what, it is not explicitly mentioned in the Constitution. But when we say freedom of speech and expression, it also means freedom of press. So freedom of press is also a fundamental right under Article 19(1)(a) of the Constitution. But this freedom of speech and expression is not an absolute fundamental right. 19(1)(a) not an absolute fundamental right. When we say not an absolute fundamental right, that means there are restrictions. When we say there are restrictions, we also say these are reasonable restrictions. And these reasonable restrictions are mentioned under Article 19, Clause 2 of the Constitution. And there are 8 grounds under which your freedom of speech and expression can be restricted. Reasonable restrictions can be imposed on your freedom of speech and expression. One such restriction is sovereignty and integrity of India. Yesterday's newspaper, the Hindu newspaper, article 1st of the Hindu newspaper, Booker Prize winner Arundhati Roy, former Kashmir University professor Sheikh Shaukat Hussain, booked for an event which happened in 2010. They were saying something. But freedom of speech and expression is a fundamental right. But what were they saying? Azadi the only way. Freedom of Kashmir, secession of Kashmir from the Union of India is the only way out. So they were saying something, but that doesn't mean you can say whatever you want to say. There are restrictions, reasonable restrictions on your fundamental right to freedom of speech and expression. And one such restriction is you can't go against the sovereignty and integrity of India. Integrity, that means the entire territory of India is an integral whole. If you say one part of the territory should come out of the Union of India, this is not your protected free speech. Although this was not the original restriction, this was a restriction which was added to the Constitution by 16th Constitutional Amendment Act 1963, which was in the aftermath of the 1962 Indo-China War. But when we say freedom to say whatever you want to say, express whatever you want to express, that doesn't mean your tongue would be like a knife, saying and uttering anything that it wants to utter. There are reasonable restrictions. One such restriction is your freedom of speech and expression should not go against the sovereignty and integrity of India. Second restriction, security of the state. For example, you have freedom of press. Is that a fundamental right? Yes. We have a journalist. What's the job of the journalist? To investigate, to write stories, to publish them in the newspaper. This is India. This is China. And we know what is happening between India and China along the LAC, line of actual control. The government of India, the army of India is planning something, is planning an assault on China, planning a military operation on China. Some tunnels have been dug, some Apache helicopters have been called in, some say even the Rafale jets will be called in. And ultimately what will happen? Through land, through air, we will mount a strong attack on China and we will destroy all the illegal establishments which were set up by the Chinese army, the People's Liberation Army of China. A journalist gets to know about this and ultimately publishes this on the front page of the Hindu newspaper. Is the journalist using his freedom of speech and expression? Yes. Using his fundamental right, which is freedom of press? Yes. But through this, he is endangering the security of the state. By giving out this information, basically you're saying, China, beware. This is what our army is planning. This is not your freedom of speech and expression, because your freedom of speech and expression should not endanger the security of the state. So say whatever you want to say, but be reasonable. Write a fictional story instead. Write a story about the mainland India. Why should you talk about an ongoing military operation or a military operation which is planned by the army or the government? By your writing, you are jeopardizing the lives of the army. You are violating the sacredness, the sanctity of this military operation. That is not your free speech. So, one ground on the basis of which your freedom of speech and expression can be restricted is the sovereignty and integrity of India. Second, security of the state. Third, friendly relations with foreign states. Let's say, for example, one of the most powerful Saudi men today is whom? Who is the most powerful man in Saudi Arabia right now? Anybody? Princess. Not the king, but the crown prince, MBS as he is known, Mohammed bin Salman. He is considered to be a murderer. Why? Because there was a Washington Post journalist, Jamal Khashoggi, who was writing articles critical of the crown prince. Ultimately, what happened? He was also a Saudi Arabian, but he was living in United States. He went to Turkey to get his visa extended. The thing is, when Jamal Khashoggi, a journalist, basically a Saudi Arabian national, but now working in United States, was writing articles critical of Mohammed bin Salman. He was in Turkey, wanted to enter the Saudi Arabian embassy to get his visa extended, entered the assembly, entered the embassy, but did not come back. And later on, it was found that inside the embassy, he was killed. His body was cut into various parts, stuffed into a box, into a briefcase, and then thrown out. So he entered in body and flesh, but he returned in a briefcase. And all the evidence pointed out to MBS that it is MBS who has ordered his assassination. But he's the most powerful man in Saudi Arabia. Even the US President Joe Biden is afraid of him. And when he shakes his hand, he shivers. Ultimately, no action was taken. But what if Mohammed bin Salman was to come to India, and he came to India recently? And what if people organize protests, demand his hanging, demand his prosecution in the killing of Jamal Khashoggi or other rights violations that he may be committing? But at the same time, Saudi Arabia and India, they want to enter into a very strong agreement, very strong partnership. Cheaper oil will be provided to India. More and more military support will be provided. More funding will be provided. The Reliance and Aramco, these two important companies, their merger would take place. Something spectacular would happen which will create jobs in India. MBS would come to India, would see people protesting against him, would read newspapers where there are people calling for his hanging. He will tell Mr. Modi, what are you doing? In Arabic slang, what are you doing? You want to have good relations with me, but the people of your country, they hate me. We are calling off all these diplomatic initiatives. So your freedom of speech and expression can be restricted in the interest of friendly relations with foreign states. That means somebody protesting or somebody writing a critical article or somebody exercising his freedom of speech and expression, those can be restricted on the ground that if you write this, it is going to affect our relations with Saudi Arabia or with any other friendly country. Originally, this was not part of the constitution. This was not a reasonable restriction. This was added by the first Constitutional Amendment Act 1951. That is why today, when the opposition is attacking the BJP, saying that this BJP government is violating freedom of speech and expression of the media, of the individuals, where you say anything and you are arrested under various laws, the BJP rightly points out that the first assault on freedom of speech and expression was done by the so-called advocate of the free speech, which is Pandit Nehru. It was under the prime ministership of Pandit Nehru that the constitution was amended, the first Constitutional Amendment Act 1951, where this illogical ground was added: friendly relations with foreign states. You can't write anything critical which will go against our interests with foreign states. But be that as it may, your freedom of speech and expression is not absolute. It comes under reasonable restrictions. One such restriction is sovereignty and integrity of India. Clear? Second is security of the state. Clear? Third is friendly relations with foreign states. Clear? Fourth is public order. And what is this public order? There was a magazine which was published from Bombay, and then it was to be transported or distributed in Madras as well. And this particular magazine, it was not allowed to be circulated in Madras. The name of the magazine was Bombay Mirror. It was considered to be a communist magazine, propagating the values of the communism. Ultimately, what happened? Madras government banned the circulation of this magazine. The petitioner approached the Supreme Court saying, "My lord, how can this magazine be banned in Madras?" Madras government said, if this magazine is allowed to be circulated and distributed in Madras, there will be riots in Madras, there will be protests in Madras, and ultimately public order would be violated, which means there will be ban, there will be stone pelting, the order in the society would be vitiated, violated. But the petitioner said, is there a ground mentioned in the constitution that on public order, your freedom of speech and expression can be restricted? No. Then how can this magazine be banned in Madras on the ground of public order? Such a restriction is not existing in our constitution. After this judgment, Parliament got together, amended the constitution, and added public order as the ground on the basis of which your freedom of speech and expression can be restricted. That means any form of expression, if it has the tendency to violate public order, if it has the tendency to vitiate peace in the society, harmony in the society, your freedom of speech and expression can be restricted. And some say this is a valid ground. Or a reasonable ground. Why reasonable? The example that I gave you yesterday. You are watching a movie in a multiplex, you are eating popcorn as well, and suddenly you cry fire, 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 because of which people try to run away from the multiplex. They start exiting the gate. There is a stampede and 40 people lost their lives. And then the police will come and arrest you, and you will say, why are you arresting me? I have the freedom of speech and expression. But why did you cry fire, fire, fire where there was none? Said, so what? This is part of my freedom of speech and expression. No, this is not, because through your freedom of speech and expression, you have violated public order. The order in the society has got violated. You will be booked. You will be arrested. But there are others who say this is unreasonable. And particularly when it comes to movies and other art forms. Sanjay Leela Bansali got Shahid Kapoor, Ranveer Singh, Deepika Padukone to come together and act in a movie. What is the movie? Padmavati. It was not acceptable to some of the people in Rajasthan, a member of a particular caste group. Protests were made, and ultimately there was a danger that this movie may be banned in Rajasthan. Why? Because movie is a form of creative expression. It's your freedom of speech and expression. Right to make movies is your fundamental right. But if your creative expression violates public order, restrictions can be imposed on your fundamental right, which means restriction can be imposed on your movie, which means the movie may also be banned. But there is a lot of investment in a movie. Hundreds of crores are being spent. Thousands of people, their livelihood is dependent on this movie. The producers, the distributors, the multiplex owners, everybody's income, money is riding on this particular movie. Ultimately, Sanjay Leela Bansali, some people even said, I will pay you 2 crore rupees if you cut Deepika Padukone's nose. Why specifically nose? I don't know. But this comes under hate speech. Freedom of speech and expression does not include hate speech. So I have the freedom of speech and expression to say whatever I have to say. I can't say Deepika Padukone's nose should be cut. That's hate speech. I can't say Hindus should not be given land in this state or Muslims should not be given livelihood in this state. That is indulging in hate speech, which is not protected under Article 19(1)(a) of the Constitution. But when Sanjay Leela Bansali got to know that there are a lot of people who are riding on me, otherwise they will go bankrupt, he accepted that there is some problem. I will change the name of my movie. So instead of calling it Padmavati, I will call it Padmavat, so that nobody comes to know it's about Padmavati. Because there's a big change. You are removing I from the movie. Similarly, Salman Rushdie wrote a book, The Satanic Verses, which the members of the Muslim community thought is derogatory towards the Prophet and his wives. Ultimately, this book was banned in India. You can't even import this book. Why? Because if any creative expression has the tendency to violate public order, that movie, that book, that creative expression can be restricted. So what are the grounds on the basis of which your freedom of speech and expression can be restricted? One is sovereignty and integrity of India. Second is security of the state. Third is friendly relations with foreign states. Fourth is public order. Fifth is decency or morality. Decency means there should be no obscenity. If I have the freedom of speech and expression, I can express whatever I want to express. Does that mean we will allow pornography in India? That's also a creative expression. But pornography is obscene, is not moral, is not decent, and as such is a reasonable restriction under freedom of speech and expression. Any art form, any creative expression, if it is obscene, immoral, lacks decency, restrictions can be imposed on that creative expression. Be that a movie, be that a song, be that a book, whatever it is. And for that, we have a classic example, Ranjit D. Udeshi versus State of Maharashtra case. This was related to Lady Chatterley's lover. Recently, it was in the news as well. Why? Because a Netflix series is made on this novel by William Lawrence, The Lady Chatterley's Lover. When this book was to be imported in India, when this book was published, when this book was circulated in India, sold in India, ultimately it was banned as well. Why? Because there were some paragraphs in this movie, paragraphs in this book which were obscene, which were erotic in nature. Matter went to the court, and this court said, yes, this book should rightly be banned. Why? Because it contains paragraphs, passages which are erotic, which are pornographic in nature, which lack decency, which are obscene, which lack morality, which lack decency, and as such should be banned. But morality is subjective. What is moral to you may be immoral to me. What is immoral to me may be completely moral to you. And this morality keeps on changing with time as well. Keeps on changing with time in the sense, movies, for example, they are a reflection of our society. The kind of movies that you see, it tells you what is the kind of audience that we have in India. It tells you what is the kind of society that we have in India. Because these movies are the reflection of the society. If you look at the Hindi movies or the Hindi cinema, look at the kind of movies that were made immediately after the independence. These are patriotic movies. Why patriotic movies? Because you wanted to inculcate a sense of patriotism in the society. But over a period of time, we saw that there was an element of corruption in the society. The bureaucrats were corrupt, the politicians were corrupt, and we needed somebody to tackle this corruption, tackle this problem that we are facing as a society. And for that, we needed one person. Any person with magical powers could do this. And then entered the angry young man, Amitabh Bachchan, and as a single individual fought against the system. But then came the period of 1991, liberalization, privatization, globalization, where NRIs became an important part, where people got a lot of money. And our movie makers started making movies for our NRI audience. So the Karan Johars and the Aditya Chopras, they started making movies for the NRI audience because now they are able to watch our movies. So the kind of cafeteria that you see in a college of a Karan Johar movie, such a cafeteria you don't even see in a five-star hotel. But you're catering to a different audience altogether. But now suddenly people are exposed to the content from Korea, the kind of content that we see on the OTTs, the Korean movies or their TV series, the kind of content that we are exposed to now from the Iranians, fantastic movies, the kind of content that we see from Nigeria as well, fantastic content. So now people are exposed to a lot of content from outside. And now people stop watching Salman Khan masala movies. They're watching some of the good content on Netflix and Amazon Prime. Why? Because now your tastes have evolved. You start appreciating better content. So society changes, kind of movies also change. Or we say movies are the reflection of the society. There was a time when if a romantic scene or an intimate scene was to be depicted between the protagonists, between the man and the woman, it was displayed by the kissing of the two flowers. But now we see a full blown romantic, erotic scenes in the movies as well. But it is another matter if Mr. X, who was previously the head of the CBFC, Center Board for Film Certification, he cut the duration of a kissing scene in a James Bond movie, saying this is against Indian culture. We should not expose our children to such kind of intimate scenes. Once his term as CBFC chief got over, he made an erotic movie. But that's the hypocrisy of a different kind altogether. But the point is, when we look at freedom of speech and expression, this freedom of speech and expression can be restricted on the grounds of morality or decency. But the only problem here is that this concept morality or decency is time specific. and varies from individual to individual. So, what sort of morality are we talking about? And that morality is constitutional morality. Not your morality, not my morality, the constitutional morality. And how do we find this constitutional morality? Look at the preamble: liberty of thought, belief, worship, freedom of speech and expression, dignity. All these are part of constitutional morality. And any book, any creative expression, any movie, any song, if it satisfies the constitutional morality, it will continue. And this constitutional morality should be contemporary. Contemporary in the sense as it exists today. Because today's morality is different from the morality of the past. Tomorrow's morality would be different from the morality of today. Maybe tomorrow, even the pornography would be considered moral by the society. And at that time, pornography becomes legal. But your freedom of speech and expression is not absolute, it comes under reasonable restrictions. On the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality or decency, these are the grounds on the basis of which your freedom of speech and expression can be restricted. But there are other grounds as well: contempt of court, defamation, incitement to an offense, which we will discuss after the break. Okay? Sir, but why then obscene books are available as e-books in India? Why there is no censorship for these? What are these obscene books which are available? We will discuss constitutional morality in great detail in our last class. Because once you have the idea of the complete constitution, then we will discuss what is constitutional morality. For receiving Bharat Ratna, no need to be the citizen of India? No. Sir, I know some politicians using some bad words to criticize the opposition, then there is also no action taken against them. If police want to take action about supporters of that party stopping and disturbing the public, is it not a loophole to escape from punishment? I could not understand your question. Yes, politicians are using bad words to criticize each other, but depends on what sort of bad words. Respect, sir, can I fly flag of India on my birthday at my house? Yes, you can do that. Sir, why government don't ban Netflix series which contain nudes? If you don't want to watch it, don't watch it. If others want to watch it, why do you stop them from watching it? Let them watch it. Live and let live. What constitutes sedition, we will discuss today. Some politicians have criminal charges, but he became MP. Tomorrow you can file a case against me as well, a criminal case. That should not debar me from contesting elections. So if there is only an allegation against me, only an accusation against me, I should still contest election. But if I'm convicted, if the court has said, yes, you are a criminal, then I cannot contest elections. Can I fly Indian flag in my car? Yes, and you can see that happening as well. Okay, let's meet at 8 a.m. See you on the other side of the break. So legislators watching obscene movies inside legislature, is it not violation of Article 19? No, because inside legislature, legislators can do anything. They have an absolute freedom inside legislature, which we will discuss in Parliament chapter. The sixth ground on the basis of which your freedom of speech and expression can be restricted is contempt of court. The contempt of court can be broadly divided into two groups or two categories or two forms. One is civil contempt, the other is criminal contempt. What is a civil contempt? For example, the court has asked you to do something. In a sense, that there is going to be a hearing on this particular case next week, you have to be present before the court. If you are not present, which means you are committing contempt of court, it's a civil contempt. Or you are telling the court that I owe 100 crores to the government. I will repay 100 crores on the 26th of January. If you have not repaid, which means the guarantee that you gave the court, the assurance that you gave to court, you're backtracking from that assurance. You are deliberately, willfully disobeying the court order, or you're committing breach of an undertaking that you have given to the court. Undertaking was that I will give this 100 crore back to the government. I will be present on the next date of hearing. If you are deliberately, willfully going against your undertaking, this is civil contempt. But criminal contempt is something which is more dangerous. What is criminal contempt? The judges have set you free in a murder case, for example, and I'm writing somewhere or I'm saying this somewhere, I'm making a YouTube video of this saying this judge set you free because you are from the same caste. This judge set you free because you are of the same religion. This judge set you free because you gave bribe to the judge. Through this video, what am I trying to do? I am sowing seeds of distrust in the minds of the people. Tomorrow, people will stop trusting the judiciary. You are scandalizing the court. You tend to scandalize the court. That is criminal contempt, and this criminal contempt is taken very seriously. You are interfering, or you tend to interfere or obstruct the course of justice. This is criminal contempt. How? Prashant Bhushan, a noted Supreme Court lawyer as well as an activist, he tweets something. What does he tweet? He says the Chief Justice of India, the then Chief Justice of India, Sharad Arvind Bobde, is riding a Harley Davidson bike which belongs to a BJP leader, that too in Nagpur, at a time when there is a lockdown and when Chief Justice of India has shut the doors of the Supreme Court and the Chief Justice of India is not wearing a mask. Freedom of speech and expression. but there can be reasonable restrictions on your freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality or decency. The sixth ground is contempt of court. What is contempt of court? You are either committing civil contempt or criminal contempt. What is civil contempt? You gave an undertaking before the court that I will give 100 crores back to the government, which you are not giving deliberately. You are committing civil contempt. The court asks you to be present on the next date of hearing, but you are not present. You are deliberately, willfully disobeying a court order. This is civil contempt. But the criminal contempt is through your freedom of speech and expression, through your speeches, through your articles, through your videos, through any art form, through any creative expression. If you are committing contempt of court, this freedom of speech will not be protected. Restrictions will be imposed on your freedom of speech and expression. For example, if you scandalize the court, what is the scandalizing of the court? For example, Prashant Bhushan tweets that the Chief Justice of India, Mr. Bobde, is riding a Harley Davidson bike which belongs to the BJP leader, that too in Nagpur, at a time when the nation is under a lockdown. He is not wearing any mask, and this is at a time when he has shut the doors of the Supreme Court for the common people, when the Supreme Court is not functioning. Assumption was, if Mr. Bobde can ride a Harley Davidson bike in Nagpur, he should also open the Supreme Court. Why is Supreme Court shut? But this was scandalizing the court. How? Number one, Chief Justice of India, Sharad Arvind Bobde, he was not riding a Harley Davidson bike. The bike was on a stand. But when you say this Harley Davidson bike belongs to the BJP leader, that too in Nagpur we have the headquarters of the RSS, the ideological parent of the current government, of the current political party which is ruling the country. Which means the sense that you are giving to the people is, through your tweet, that this Chief Justice is very close to the BJP, very close to the RSS, and he has shut down the Supreme Court. While in reality, the Supreme Court was not shut. Virtual hearings continued. Only the in-person hearings, the physical hearings stopped, but virtual hearings continued. Through this tweet, you are tending to scandalize the court and saying that the court is biased in favor of the ruling party at the center. Whenever contempt proceedings are to be initiated against somebody, you can file it in three ways. One, the Attorney General for India approaching the court. Second, the court acting suo motu, which means on its own. Third, any third person with the prior consent of the Attorney General for India. So if Prashant Bhushan has tweeted this, who can file a case against Prashant Bhushan? Or for that matter, Kunal Kamra, the comedian, the stand-up comedian, he said in response to the Arnab Goswami case, when Arnab Goswami was arrested by the Maharashtra police, then he was thrown into the jail. Ultimately, Supreme Court quickly heard this matter and set Arnab Goswami free, saying journalists have an important role in the society. Kunal Kamra said, why special treatment was given to Arnab Goswami? Why was his case heard instantly, while there are thousands of cases which are pending before the court? And Kunal Kamra said, Chief Justice of India, Justice D.Y. Chandrachud, is like that air hostess who is serving champagne only to the first class passengers, while the passengers of the economy class, they are struggling to get on board that aircraft. If you think that a particular individual has committed contempt of court, if I am writing tomorrow that the judges are corrupt, if I'm writing tomorrow that the judges have taken bribe to give Ayodhya verdict or EWS judgment or other judgments, who can file the contempt of court case against me? One, either the Attorney General for India should himself approach the Supreme Court and say, please take action against Prashant Bhushan, please take action against Kunal Kamra, please take action against Sarmad because they have committed contempt of court. Or the court will act suo motu on its own. The judges will read this tweet, will watch this video, will read this article, and its on will say, now contempt of court proceedings will be initiated against you. If not the court itself, if not the Attorney General for India himself, then any third person, you, her, she, anybody can approach the court. But you have to first take the consent of the Attorney General for India. Why? Because this is to save the time of the court. If, for example, every random case goes to the court, contempt of court, the court will be overwhelmed with number of petitions, and we may not know whether these petitions are genuine or not. That is why the rules say all these contempt of court proceedings, either this case can be filed by Attorney General or the court on its own, or if any other person wants to file this case, first you have to take the consent of Attorney General, so that Attorney General can look through your complaint and then decide whether it's a genuine complaint or not. If it's a genuine complaint, then Attorney General will ask the Supreme Court, please hear this case. Otherwise, a lot of time would be wasted. And when contempt of court petition was filed against Prashant Bhushan, the Attorney General said this is a fit case for contempt of court. Ultimately, the court imposed 1 rupee fine on Prashant Bhushan for committing contempt of court. Why? Because the Attorney General said, yes, he has committed contempt, but he has also played an important role in judiciary. He is taking up cases of the poor without charging them any money. So he has done a lot of good work as well. So considering his good work into consideration, keeping that good work into consideration, let's impose 1 rupee fine on Prashant Bhushan. But the point is clear. If you commit contempt of court, it is not your freedom of speech and expression, because your freedom of speech and expression can be restricted if you scandalize the court, if you tend to scandalize the court. But in 2006, significant amendments were made to the law. There is a law known as Contempt of Courts Act, Criminal Contempts of Court Act, 1971. And this law was being misused. Misused in the sense, sometimes the judges are also thin-skinned. Any small criticism, they say this is contempt of court. You don't agree with this judgment, you write in your article, I don't agree with this judgment, the court will say you are committing contempt of court. How can you say we don't agree with this judgment? You are scandalizing the court. Which basically means then no honest criticism of the Supreme Court can ever take place. I want to criticize the Supreme Court for the way they gave Shabarimala judgment, or they gave instant triple talaq judgment, or they gave the EWS judgment, or they gave the Ayodhya judgment. I want to criticize. I want to point out loopholes in this judgment. I can't do that. Why? Because the court will say you are committing contempt of court and I will be punished. I want to expose corruption in the judiciary. And if I say these judges are corrupt, you will say you are committing contempt of court. Then how do we reconcile freedom of speech and expression and restrictions on your freedom of speech and expression? In 2006, 2 amendments were made. One, no criminal sanction can be imposed for contempt. Nobody shall be convicted for contempt if the court is satisfied that the contempt is of such a nature that it substantially interferes or tends to interfere with the due course of justice, or if the court permits truth as a valid defense in public interest or bona fide in good faith. What does that mean? If 5 judges of the Supreme Court in 2019 said that this 2.77 acres of disputed land at Ayodhya belongs to Lord Ram so that a mega Ram temple can be constructed at Ayodhya. This is the judgment of the court. It has to be implemented. If you're not satisfied with this judgment, you can file a review. Supreme Court, please review this judgment. But you can't say and you can't do that. Let's come together. You're instigating the people. Let's come together and occupy this 2.77 acres of land so that we will not allow the government to acquire this land. We will not allow Lord Ram's temple to be constructed on this land. What are you doing? You are substantially interfering with the justice. Supreme Court said this land belongs to Lord Ram so that Ram temple can be constructed. If you occupy this land and say we will not let this judgment be implemented, you're interfering with this judgment. Whoever does that, although you're expressing yourself, whoever does that will be booked. But if you're only criticizing this judgment, saying this judgment was not right, these are the loopholes of this judgment, you're not interfering with the implementation of this judgment. No action will be taken against you. And second, the court will permit, if you're saying truth, if you're exposing corruption in the judiciary by saying that these judges are corrupt, if you're exposing corruption in the judiciary, but if you're saying this on some valid grounds, if you have some data to back it up, if you have truth, then even if you are saying that the judges are corrupt, but since this is truth, no action will be taken against you. And for that, we have one classic example. What is that classic example? Maninder Singh versus State of Punjab. It was argued that Maninder Singh had raped his own daughter. Matter went to Punjab and Haryana High Court, and Punjab and Haryana High Court imposed death penalty on Maninder Singh, saying this is the rarest of the rare case. And what is this doctrine of rarest of the rare, which originated, which was given by the court in various judgments, Bachchan Singh case and others? Every murderer will not be given death sentence. Every rapist will not be given death sentence. Every terrorist will not be given death sentence. Death sentence can be given only in the rarest of the rare cases. And this was told by the Supreme Court in the Bachchan Singh case. And what is this rarest of the rare case? If we do not award capital punishment, if we do not award death sentence, it would lead to injustice. If such a case is existent, if such a case is presenting itself, then this is the rarest of the rare case. Rarest of the rare case, you have to draw a balance sheet. Of aggravating and mitigating circumstances. Listen to me carefully. A murder takes place. Who is the murderer? This murderer was hungry for the last 7 days. There's nothing to eat. His family is struggling. They don't have anything to eat. The mother and the father, they are sick. This individual went to a shop, a grocery shop, asking for some food items to be given. I will pay you later, but my family is hungry. I am hungry. Please give me this grocery item. I will pay you later. This shopkeeper is pushing me, saying, get lost. In a fit of rage, what I do, I take out a knife and kill this individual. Is this murder? Yes. Should I be punished? Yes. But should death sentence be awarded to me? That you decide. How do you decide? By looking at mitigating circumstances and aggravating circumstances. What are the mitigating circumstances? This person has never committed any crime previously. This was his first crime. So he's not a habitual criminal. And look at the conditions in which he committed this murder. He was hungry, his family was sick, his family was hungry. He only asked for a grocery item or a piece of bread. And for that, there was a brawl, there was a disagreement, there was a fight. And ultimately, in a fit of rage, he had not planned this murder. So this was not a predetermined, pre-planned murder. This just happened in a fit of anger, in a fit of rage, and then he killed him. Look at all these circumstances first, because you don't have to only look at a crime, you have to look at the circumstances in which that crime was committed. That doesn't mean I condone your activity. That doesn't mean I condone your murder. You are a murderer. You will be punished. But maybe not death sentence, maybe life imprisonment. Why? Because these circumstances tell us that maybe there is still some scope of reform. Because this was not a predetermined murder, which means maybe you will regret later on. Let you suffer in the jail for 14 years or 20 years. Maybe you will reform in the jail and then you can go back to the society and serve the society. Be part of the society again. But what if I tell you that here is one girl, Nirbhaya, December 2012. She, along with her friend, they go and watch a movie. Once they return from the movie, they board a bus. The bus is with the tinted glasses. Nobody can see from outside what is happening inside. And there are 6 men inside the bus. One is a juvenile, less than 18 years of age as well. They take turns to rape this girl. And after raping her multiple times, they take out an iron rod and insert this iron rod into her private part, which ruptures her intestines as well. And then what they do, they throw the couple down on the road and then they push this bus on them as well. There is something grotesque about this crime. There is something horrific about this crime. These are aggravating circumstances. Rape and rape. There is a rape where one person under the influence of the alcohol has raped a woman. You can't justify that, but it is a different rape. Then there is a rape of this kind. It's a gang rape where 6 men are ganging together to rape you and then inserting iron rod. All these aggravate this crime, make this crime more horrible. If in this case death sentence is not given, it won't lead to justice. Death sentence alone is an option, because these are vultures who can never be reformed. Otherwise, they would not commit such a crime in this fashion. So Supreme Court has said that the death sentence should be awarded not in any case of murder, not in every case of dacoity, not in every case of rape, not in every case of terrorism. The death sentence can be awarded only in the rarest of the rare cases. So whenever a case is presented before the judge will have to look at what are the circumstances in which this crime was committed. Are there some circumstances which aggravate, make this crime even more horrific? And then decide whether this falls in the category of the rarest of the rare case or not. Maninder Singh, when he raped his own daughter, Mehta went to the court said this is the rarest of the rare case. This is a horrific crime. This is not a normal rape. You're raping your own daughter. Mehta went to the Supreme Court. Supreme Court said no, this is not the rarest of the rare case. It happens. Father rapes his daughter. It happens. This is not the rarest of rare case, but that doesn't mean we allow this to happen. Not death sentence, life imprisonment should be given to Moninder Singh. Okay. Moninder Singh was serving his life imprisonment, but then he was released on parole. Just like Sanjay Dutt was released on parole, which means you are serving your time in the jail. Let's say you are sentenced to life imprisonment, but for some important needs, you can be released on parole. There is a death in the family, you want to attend the funeral. There is a wedding in the family, you want to attend that wedding. You have to take the permission of the jail authorities. If the jail authorities are satisfied, you can be released on parole. That means you can be released on 15 days and then you'll have to come back and serve your time in the jail. Moninder Singh was released on parole. And while he was on parole, he killed the same daughter he had raped. He also killed his wife. Matter went to the Punjab and Haryana High Court again. Why? Because this is another offense. Punjab and Haryana High Court said, now this is the rarest of the rare case. He was serving his time in the jail for raping his daughter. Now he's released on parole. He killed the daughter, he killed the wife as well. This is the rarest of the rare case. Hang Moninder Singh. January 2013. Two judges of the Supreme Court, Justice Sathasivam and Justice Khalifullah. These were the two judges who were hearing this case. The judges said, no, this is not the rarest of the rare case. Moninder Singh should not be awarded death sentence. Moninder Singh should be awarded life imprisonment. This was January 2013. 2 weeks later, again January 2013, the same judge is hearing another case of murder and kidnap. A 7-year-old boy was murdered. He was first kidnapped and then murdered. Now the same judge is hearing this case. The same judge who said Moninder Singh, his case does not fall in the category of the rarest of the rare case. Basically saying, so what, he killed his daughter, he killed his wife, the same daughter he had raped previously, for which he was serving life imprisonment. But this is not the rarest of the rare case. This is a crime for which life imprisonment should be given, should be sufficient. But the same judge is now hearing a case where a 7-year-old boy was kidnapped and then murdered. The judges said this is the rarest of the rare case. Why? Because the judge said, imagine the plight of the family who lost a male child. And this male child would have carried forwarded the family lineage. If I were to ask you, compare the two cases and tell me what case do you think is the rarest of the rare case? Rape of the daughter, then killing her and then killing the wife as well? Or the murder and the kidnap of a 7-year-old boy? Both are horrific crimes. Can't be compared. But if at all you have to decide what constitutes rarest of the rare case, it clearly should have been the Moninder Singh case. But the gender bias, the patriarchy, judges are also part of the society. If society is patriarchal, judges will also be patriarchal. Heavy criticism was leveled against these judges who gave this judgment. But and judges were accused of being patriarchal, gender biased. This judgment was considered to be horrible, the worst judgment written in the history of independent India. Does that mean you are scandalizing the court? Or you tend to scandalize the court? No. Why? Because truth is the valid defense. When these journalists, when these editors who wrote these articles, they were booked for contempt of court, matter went to the court, the Attorney General said, no, this is not contempt. Why? Because they are saying the truth. Truth is their defense. They're not saying something new. They're not saying something that they have cooked on their own. They're saying the truth that the judges are patriarchal by citing the very judgment. So truth is a valid defense. Even if you criticize the judiciary, even if you lambast the judiciary, but you are saying this on the basis of facts, ground reality, you won't be charged with contempt. But the sixth ground on the basis of which your freedom of speech and expression can be restricted is on the grounds of contempt of court. Clear? Contempt of court is applicable for Supreme Court or for all the courts. All the courts, but Supreme Court can punish people who commit contempt of Supreme Court. High courts will punish those people who commit the high court contempt of high court. But if you're committing contempt of the district court cannot punish you. On behalf of district court, the concerned high court will punish you. So only the high courts and the Supreme Courts have the power to punish contempt of itself. So third person includes Attorney General himself. Attorney General is at serial number 1, first person. Third person can be, first person is the Attorney General. Second can be the Supreme Court judge himself. Third person can be any other random person. So how can third person be Attorney General? Sunny Dutt is now released or on parole. Sunny Deol is in parliament. Sanjay Dutt's term is over. So does contempt of court apply against government? Yes, government can also be punished for contempt. What is the difference between bail and parole? Bail is when the case is still ongoing. So an accused is released on bail. A convicted person is released on parole. So I am already convicted. The court has said you are guilty. I am now serving time in the jail. I can be released on parole. So parole is for convicted people. Bail is for accused. FIR against Bhushan but not removed from MP. Who is that Bhushan? Brij Bhushan, who is the wrestling chief, was the wrestling chief, or Prashant Bhushan? What happened? They will leave the country during parole. They won't, because they will have to, their passports would be confiscated. Is there any fixed duration of parole? Parole comes under prison rules. Prison is a state subject. That means in the distribution of power, states have the right to have their own prison rules. So the rules governing parole, they vary from state to state. Okay. You have the fundamental right to say whatever you want to say, express whatever you want to express. And after this class is over, you say, this person who teaches polity in Byju's, he's a criminal, he's a terrorist, he's a thief, he's a murderer. You're basically defaming me. If you have freedom of speech and expression, I have the right of my reputation as well. If you are saying truth, that yes, I'm a murderer, then I can't take any action against you. I'm a murderer. But if you're lying, you're trying to defame me by saying that this person takes money from the students and does not teach them. Although students pay Byju's, but this person is now asking them, you pay money to me, then I will teach you, otherwise I will not. Or I will give you personal counseling for the money that you will pay me. I will give you the account number, you pay money in that account, otherwise I will not teach you. You're basically defaming me. This is something that you cannot do. So if you defame me, I will go to the court. This is not your freedom of speech and expression. Defamation can be of two types, libel or slander. If you are writing something, if you are in your book, in your novel, in your article, on your blog, if you have written something which is defamatory against me, that is libel. Slander is if you are saying something in spoken words, at a speech, if you are saying something. For example, Mr. Ravi Shankar Prasad, he gave a speech in Bihar, and he said Dr. Shashi Tharoor is a murderer. He has murdered his wife, Sunanda Pushkar Tharoor, and now he's giving speeches on morality, decency, integrity, so on and so forth. Shashi Tharoor shot a letter to him. You have defamed me. Why are you saying that I'm a murderer? The court has not said that I'm a murderer. Why are you saying I'm a murder accused? The court is not even saying that my wife was murdered. It was a natural death. And Ravi Shankar Prasad said, sorry. Sorry, otherwise you will file a case against me. This case will drag on. I will be sentenced to jail. I'm sorry. I apologize. Because I have the freedom to say whatever I want to say, but it cannot be unrestricted. You cannot be defaming somebody because they also have the right of reputation. So defamation is the seventh ground on the basis of which your freedom of speech and expression can be restricted. And the eighth ground is incitement to offense. I have the freedom of speech and expression, but I tell all my students today, please raise your arms, have AK-47, and let's kill these people. Please raise up arms. Let's throw mines, let's throw grenades and bombs at this particular school or this hospital. I'm inciting you to commit violence. This is not part of my free speech. This is not my freedom of speech and expression. I cannot be inciting people to offense. These are the eight grounds on the basis of which your freedom of speech and expression can be restricted. Then comes sedition. Article 124, capital A. Part of the Indian Penal Code. What does the text of sedition law say? Section 124, capital A say, whoever by words, either spoken or written, or by signs, or by any creative expression, or by cartoons, if you want to excite disaffection towards the government established by law, it is sedition, and we will sentence you to life imprisonment. For that, you need to understand the history. History of this sedition law. Initially, when Britain, East India Company, and then the British government, the Crown of British controlled this country, controlled the people of this country, maybe people did not even realize that we are under an alien government. We are under the control of the foreign government. So how do you make people aware? By giving them education, by educating them, by telling them that we are not governed by Indians. We are not governed by ourselves. We are governed by a foreign power. That is why when Indian National Congress was created, established in 1885, and even before that, the primary purpose of the political leaders was education. They would publish pamphlets and distribute it to the people. They will go to the nookards, the areas, and will give speeches to the people, educate them that this is not our government. We need our government back. So this government is a foreign government, an alien government. We need our government back. The British realized that through these words, through these speeches, through these pamphlets, through these articles, through these drama performances, through theater, what are these Indians trying to do? They are trying to excite, promote disaffection against the government established by law, which is the British government in India. So through your words, through your articles, through your speeches, through your movies, through your theater, through your dramas, you are trying to promote disaffection against the government, which is the British government in India. The law said this is sedition, you can't do that. So the primary intention was of this law was to prevent the feeling of national consciousness, was to prevent the spread of this information that we are governed by the foreign rule, by a foreign power, was to prevent and suppress the feeling of nationalism in India. And the classic example of this law was Lokmanya Tilak. Plague had hit Pune. It was Pune then, plague had hit, and the government was criticized in the manner in which the government reacted to this plague. In a sense, they were horrible. They would go to the houses, check people if they have plague, and ultimately strip them naked as well. There were two important officials who were responsible for controlling plague or plague in India, and those were killed by Chapekar brothers. You would read that in history. And ultimately, Lokmanya Tilak had two important newspapers, Kesari and Maratha. Kesari was in Marathi, Maratha was in English. And what Lokmanya Tilak did, he published a poem which praised the killing of Afzal Khan by Shivaji Maharaj. You may have read about the killing of Afzal Khan by the sword of Shivaji Maharaj. So when this poem was published in the newspaper, which was edited by Lokmanya Tilak, and on the other hand, Chapekar brothers had killed the plague commissioners in Pune, British realized and drew equivalence and said, if you are justifying the killing of Afzal Khan by Shivaji Maharaj, basically you are justifying the killing of Rand brothers, those who are responsible for the controlling plague in Pune by the Chapekar brothers. Tilak was booked for sedition. Why? Because through your writings, you are promoting disaffection against the government established by law. Lokmanya Tilak tried to convince the judge that I'm not promoting disaffection. How am I promoting disaffection? I'm not. The judge said, I understand you are not promoting disaffection, but in your eyes, I don't even see affection for the British government. So this lack of affection in your eyes for the British government, this is seditious. You're sentenced to 6 years in jail. Then Lokmanya Tilak, few years later, was again booked for sedition. Again, he said, I'm not guilty. I'm not promoting sedition. I'm not promoting disaffection against the government established by law. Then came the trial of Mahatma. Mahatma Gandhi was booked under sedition because of what happened at the Chori Chora, and then Mahatma Gandhi was arrested. Mahatma Gandhi was asked by the judge, have you committed sedition? Are you promoting disaffection against the government established by law? Mahatma Gandhi said, yes, it's my duty to promote disaffection against that government which is corrupt, disaffection against that government which is snatching the right of my people. It is my duty to promote disaffection. The judge said this is sedition. So this sedition law was misused during the colonial period, during the independence struggle, and primarily was used to target the nationalist leaders, target the freedom fighters. When the constitution was being debated, there were some who said sedition should be retained, because afterwards, no citizen should promote disaffection against the government of India or the government of a state. Others said, what are you doing? Are we an independent country now, or are we still a colonial state? If the government is not doing its job properly, shouldn't the citizens have the right to promote disaffection against that government? If the government is corrupt, shouldn't the citizens have the right to protest and promote disaffection against the government? We are not talking about promoting disaffection against the nation of India. That is not allowed. But promoting exciting disaffection against the government of India, the government of a state, that should be allowed. And ultimately, Constituent Assembly members said, yes, this should be allowed. That is why sedition was not a ground, was not a reasonable restriction on your freedom of speech and expression. That is why there were 8 grounds in the Constitution. Originally 4, later on 4 more were added. But sedition was not a ground on the basis of which your freedom of speech and expression could be restricted. But then came the Kedarnath Singh case, 1962. Supreme Court said sedition law is constitutional. Why? Because a pre-independent law, if it is in agreement with fundamental rights, it will continue. But if a pre-independent, pre-constitutional law violates fundamental rights, it will not continue. The question before the court was, is section 124 capital A constitutional or not? Because the wording of this section says, if you promote disaffection against the government established by law, whether through words, whether through cartoons, whether through any other creative expression, Supreme Court said, no, sedition is constitutional because you cannot be promoting disaffection against the government by inciting violence. The court said you can promote disaffection. But if you are promoting disaffection in such a manner that you are telling people, please take up arms and overthrow this government, that we will not allow. Why? Because what is the demand of the secessionists in Jammu and Kashmir? They want to overthrow the government. What is the demand of the Maoists, the Naxalites? They want people's rule. They want this government to be abolished. They want this government to disappear. And they want to control and capture the power through violence, through arms, through ammunition. Court said this cannot be allowed. Promoting disaffection through peaceful means is allowed. But if you promote disaffection by inciting people to violence, this is not allowed. This would be sedition. So anybody who is inciting people to violence to overthrow the government, to promote disaffection against the government, that is sedition. Further, in Balwant Singh versus State of Punjab, some important matters were brought before the court. What are these matters? 1984, there was Operation Blue Star, where there were some militants who were holed up inside the Golden Temple. One such individual was Bhindranwale. Bhindranwale, a radical leader who claimed to be the leader of Khalistan. They wanted Sikhs to form a separate country known as Khalistan, which is the reason of discord between India and Canada these days. A lot of to and fro happening between the two countries. And when Bhindranwale was inside Golden Temple, the government of the day, Srimati Indira Gandhi's government, they thought that the best way is to send the army to the Golden Temple to kill all these terrorists. Otherwise, they will overthrow us. Otherwise, they will start attacking us. And ultimately, Bhindranwale and his colleagues were killed, but Golden Temple also suffered destruction. Golden Temple, which is a revered sacred site for the Sikhs, Indira Gandhi as the Prime Minister had Sikh bodyguards. Intelligence agencies told Indira Gandhi that you should replace these Sikh bodyguards because you never know. She said, no, nothing will happen to me, and it won't send a right signal as well that I'm replacing my Sikh bodyguards. And then these Sikh bodyguards pumped dozens of bullets inside the heart of Indira Gandhi, and she was assassinated. When she was assassinated, unfortunate riots broke out in Delhi and in other parts of India. Riots between Hindus and Sikhs. Rajiv Gandhi, the son of Prime Minister, who later on became the Prime Minister, He was asked what is happening in Delhi. Riots are taking place. Sikhs are being slaughtered, murdered, tortured in Delhi. He gave a very infamous statement. He said, when a big tree falls, the earth under it shakes. Some people alleged that Amitabh Bachchan also instigated riots. Some said Sajjan Kumar, Jagdish Titler, Kamal Nath also instigated rioters to kill Sikhs in Delhi. And then there were slogans raised by the members of the Sikh community, Raj Karega Khalsa, Khalistan Zindabad. When these slogans were raised, some people were arrested. They were arrested for sedition. Why? Because you are promoting disaffection against the government of India. Matter went to the court. Court said these slogans doesn't matter. Raj Karega Khalsa, Khalistan Zindabad, these are only slogans. Sedition is when you are inciting people to violence, to promote disaffection against the government. Mere slogans does not constitute sedition. And all those people who raised those slogans, they were set free. Then came Shreya Singhal case. The case we discussed in the first class when we spoke of section 66 capital A. In Shreya Singhal case, the Supreme Court perhaps for the first time explained what is a speech. Freedom of speech, as we call it. What is the speech? Supreme Court said, promote whatever you want to promote. Any idea that you want to promote it. Advocate whatever you want to advocate. Do that. But don't incite people to violence. If you want to promote something, propagate something, any idea, even if it's a radical idea, do that, but don't incite people to violence. But we also saw over a period of time, sedition law was misused. Journalist Vinod Dua, he made a video on YouTube and he said, the way lockdown has been imposed in this country in the aftermath of the COVID-19, if we don't provide food, shelter to these migrants who are migrating from cities back to their villages, there will be riots for food. An FIR was filed, sedition case was filed against Vinod Dua. Why? Because you are instigating people to violence. A filmmaker from Lakshadweep, she was also arrested for sedition because she gave some speech. That means sedition law was being misused, overused, hyperused, abused, where a mere criticism of the government was considered to be sedition. Because the Supreme Court has clearly said, unless and until you are inciting people to violence, it is not sedition. No matter what you say, how you say it, what you say will not be sedition unless and until you are inciting people to violence. Supreme Court last year said, all these cases will be paused. No further sedition case will be filed. All those cases will be paused till the time we decide whether sedition law should continue or not. And that is why in the new bill, in the new IPC, which is being spoken of, which is being debated, sedition has been dropped. That means this sedition law will not continue. And the Supreme Court also has said we will review whether the sedition law continues or not. That is why even Arundhati Roy, the professor from Kashmir University, Sheikh Shaukat Hussain, they were not booked for sedition. Why? Because the Supreme Court has said no new cases of sedition can be filed. That is sedition for you. Any questions? Can a person C file a defamation lawsuit against a person Y for the defamation of person X? No, it has to be by person X. Private individual can receive gifts from foreign country without president assent as they do not work under the state. Please tell sir. Yes, you can. What is the gift that you're expecting from a foreign country? Sedition has not been removed. The cases will not continue till the time Supreme Court decides upon the constitutionality. What is incitement to an offense? Something that Naxalites are doing, Maoists are doing. They're raising arms, weapons, to overthrow the government by telling the people that you should also raise your arms because this is not your government. We have to create our own government, people's government. You're inciting them to commit violence, triggering them to commit violence. Why government don't case sedition against Dhruv Rathi? Why? What has he done? Sir, was there caste system in Muslims? India is unique. In a sense, there was caste system in India, and all the other religions who came from outside, Christianity, for example, Islam, for example, although they did not have caste system, but once they came to India, they developed caste system in India as well. So caste system something you don't find in other Muslim countries, but you find it in India. Dhruv Rathi spoke against BJP. Speaking against a political party is not sedition. Speaking against the government is not sedition. Promoting disaffection against the government is not sedition, unless and until you incite people to commit violence. Sir, a 12-year-old girl was raped in Ujjain. Isn't it the rarest of the rare case? That depends upon the judges. If the judges view this as the rarest of the rare. What about Kerala files, Kashmir files, which are violating public order? It did not violate public order because there was no violence once this movie was released. If you don't like a movie, don't watch it. If you think that a movie is propaganda, make a counter movie. Write a review. Who is stopping you from doing that? But you should not call for banning of these movies. Why? Because it is Hindustan, it's not Banistan. You can't be banning things randomly. Let there be a mature society where we accept each other's views. That's what Voltaire said. I disagree with what you say, but I will defend till death your right to say it. That's how we can become a mature society. If an institute is being defamed, can any individual associated with the institute file a defamation charge? Unless and until you prove that you constitute a class. And as a class, you have been defamed. Just like Rahul Gandhi's case, where one Mr. Modi filed a case saying that Mr. Rahul Gandhi has defamed all the Modis. Uh, Ideally, it is not a case of defamation because how can you say that you constitute a class and you have been defamed? Others have not been. But if you can convince the court that you constitute a class, then yes, defamation can be filed. What about Tamil Nadu CM son who spoke against Hindus? Did not speak against Hindus, he spoke against Sanatan Dharma. His idea of Sanatan Dharma, he says that his concept of Sanatan Dharma says untouchability is practiced there. Okay, now let's look at Article 19(1)(b) because we discussed Article 19 There are various natural rights under Article 19, but we focused more on Article 19(1)(a) because this is a very important fundamental right, almost always in the news. That's why we'll have to discuss in great detail. Now we will discuss other fundamental rights under Article 19 one by one, briefly, because these are not of much significance for the exam, except few points which you have to remember, which we will discuss. Article 19(1)(b), right of assembly. As citizens, you have the fundamental right to assemble at a public place. That's your fundamental right, which means right to hold meetings, take out processions. That is your fundamental right. But even this fundamental right is not absolute. There are reasonable restrictions. Restrictions such as, after this class is over, all the students attending this class will make a group and will come to my home. Said, how can you enter? Stop, you can't enter. Why, sir? We have the right of assembly. We can hold meeting, procession at any place, and we are entering your house. You can't stop us. Don't violate our fundamental rights. Said, my dear, I'm teaching you polity. Don't teach me polity. Right of assembly at a public place, not my private place. So please go. Although I will offer you tea, coffee once you come, but I can also refuse you admission. So one such restriction is it has to be a public place. Second, it must be unarmed and peaceful. So if you are taking out a procession, if you're assembling somewhere with guns and gulabs, gulabs are okay. But if there are guns, then this assembly will not be allowed. Why? Because this is not a peaceful assembly. You might commit crimes. You might kill people. It will threaten public order. In the interest of the public order and the sovereignty and integrity of India, there can be restriction on this right as well. For example, in the interest of public order, as citizens, do you have the fundamental right to take out procession? Yes. Which means, can you take out processions on Ganpati festival or Durga Pujo, for example? What if on the same day there is a Muharram as procession as well? Two communities having their own rituals, but if the route taken is same, they will mix together and kill each other, unfortunately. If the government realizes this, the government will impose restriction. Durga Puja festival or Ganpati festival, this procession will go from this route. Muharram procession will take the other route. Can you approach the court? My lord, my fundamental right has been violated. How? Sir, I wanted to take this route to take out the procession of Muharram. But the government is saying, no, you can't do that. You have to take another route. Why should I take a different route? I have a fundamental right to take out a procession. The court will say, calm down. This is not an absolute fundamental right. In the interest of public order, we can restrict your fundamental right. You guys are vultures later on. You will start killing each other. That is why the procession of one religion from one route, the procession of another religion from another route. Don't merge the two routes. Restrictions can be imposed. Similarly, in the interest of sovereignty and integrity of India, there can be restriction on your right of assembly. For example, if there are people who are coming out in large numbers, they want to come out of the Union of India. They want to take out a procession saying we need complete independence from India. Such a procession will not be allowed. Why? Because you want to secede from the Union of India. You are going against the sovereignty and integrity of India. So yes, you have the right of assembly. That means as citizens, you have the fundamental right to assemble peacefully at a public place without arms, to take out processions. But this fundamental right is not absolute. It comes under reasonable restrictions. In the interest of sovereignty and integrity of India, in the interest of public order, there can be restriction on your right of assembly. Clear? That is why in the interest of public order, we also see that outside the examination hall, there is Section 144, which is imposed. Assembly of more than 4 people is not allowed. Why? You can approach the court. My son is taking an examination. This is the 10th class examination, matriculation. And we are a family of 10,000 people. We want to take out a procession and reach there, the examination hall, and start shouting slogans. Attempt question number 1, question number 2, question number 3. You're violating public order. This will not be allowed. Clear? Isn't UAPA analogous to Sedition Act? We will discuss UAPA later. And if you are assembling somewhere, but you're blocking an important highway, blocking an important road, causing inconvenience to others, this may not be allowed either. So your fundamental right ends there where someone else's fundamental right starts. Sir, you are telling that inside legislature they can do anything. That means they can do murder as well? They can, but then they will be arrested. The point is, when I say they can do anything, that means they can do all the things like saying whatever they want to say, expressing whatever they want to express. They can do that inside the legislature. 19(1)(c), right to form unions, associations, and cooperative societies. As citizens, you have the fundamental right that you can form unions, employees union, students union, associations, resident welfare association, cooperative societies. This term cooperative society was added by the 97th Constitutional Amendment Act. Cooperative society, for example, Amul, Nandini. Amul, for example, all those milkmen, they put together milk, give it to a society known as Amul, a cooperative society, and then milk products are manufactured. Whether it is paneer, whether it is ghee, whether it is curd, whether it is any other drink. And ultimately, whatever proceeds are generated, that profit is distributed and shared with these people. So, cooperative society. That is your right. You can form a cooperative society, you can form a union, you can form an association. But even this fundamental right is not absolute. This fundamental right can be restricted. Restricted in the interests of sovereignty and integrity of India, public order, morality. Public order, for example. After this class is over, you would say, Sir told me that we have the fundamental right to form a union, association, and a cooperative society. And today I'm forming one association. What association? Al Qaeda, Lashkar-e-Toiba. But these are terrorist organizations. These organizations, they will violate public order by committing the acts of terror. That is not your fundamental right because there are restrictions. Similarly, restrictions in the interest of sovereignty and integrity of India. You create a political party or you create an organization, and through that organization, you say, we want to secede from the Union of India. That means you're going against the sovereignty and integrity of India. No, you can't do that. That is how Jammu and Kashmir Liberation Front was banned. That is how Jamaat-e-Islami in Jammu and Kashmir was banned. That is how Ulfa in Assam was banned. That is how various organizations, the PFI, Popular Front of India, has been banned. Why? Because you can't go and form an association, an organization, which goes against the sovereignty and integrity of India. Similarly, morality. all those who believe in, let's say, pornography or child pornography, to be specific, we will together form a union. All India Pro Child Pornography Association. This is against morality because child pornography is considered to be immoral in India. Such an organization, if you form and the government bans it, you can't go to the court. My lord, my fundamental right has been violated. What fundamental right? 191C. What is that fundamental right? I have the fundamental right to form any union, association, or a cooperative society. And what sort of association you wanted to form? We formed All India Pro Child Pornography Association. I said, go to hell, get lost. There's a reasonable restriction on your fundamental right to form union, association, and a cooperative society. Okay. Then Article 19(1)(d) and Article 19(1)(e) are mostly similar with some difference. Both of them have the same objective. Fraternity. We are a land of diversity. From north to south, from east to west, enough diversity. You will find every 40 kilometers either the language changes or the dialect changes. Food, dressing sense, language, caste, tribe, religion, so much diversity. Yet we have to be bound by oneness that we are Indians. That's the constitutional objective of fraternity, a sense of common brotherhood. Although Constitution does not talk about sisterhood, brotherhood. And how do we implement this? Through two important fundamental rights. How do we build a sense of fraternity when you can move freely throughout the territory of India? Nobody can stop you from going to Tamil Nadu, or stop you from entering Telangana, or stop you from entering Gujarat. Throughout, no matter from which place you are, from which state you are, what language you speak, you can move freely throughout the territory of India. And you can reside and settle anywhere within the territory of India. Both these fundamental rights, right of movement and right to reside and settle anywhere within the territory of India, both these are there with the same objective to ensure fraternity, to implement fraternity. But even this fundamental right is not absolute. Why? Because in the interest of the general public and for the protection of the interest of any scheduled tribe, this fundamental right can be restricted. Right of movement. And suddenly you decide to go out and there is police party waiting for you, you are being arrested. Why are you arresting me? So there is no right of movement. How dare you say this? I have no right to movement. I've studied the constitution. I'm studying polity from Sarmad sir. He can't lie. 19(1)(d) is a fundamental right of movement. Sir, there is a lockdown. There is COVID-19 pandemic. There is restriction on your right of movement. You can't do that. Really? Yes. Reasonable restrictions can be imposed on your fundamental rights. And one such restriction is in the interest of the general public. Your right of movement can be restricted. Similarly, there are individuals who are habitual offenders. Habitual offender, you are habituated to commit offense. It becomes as if it's your habit. And one such reason given for that is that you are part of that atmosphere, that environment which fuels your desire to commit crimes. For example, if I'm a thief, I'm a habitual thief. I will commit theft here, then I will go to jail. I will come back, I will commit theft again. Then I will go to jail, I will come back, I will commit theft again. And this process continues because I am habituated to this. This becomes my habit. In this case, I would be exiled from my state. You are thrown out from the jail. For 2 years, you are thrown out of your state. For 2 years, you should not come back. Why? Because it is this environment which is responsible for your committing theft. You should better stay in a different environment for 2 years and then come back. Maybe till then you would be a changed man. Habitual offenders, they can be exterminated, they can be excommunicated, they can be thrown out of their state. That means their right of movement can be restricted. You cannot come back to the state. Why? Because it is in the interest of the general public. Because if you are here, you will commit theft again and the general public will be inconvenienced. Similarly, in the interest of the scheduled tribes. For example, Jarawas of Andaman, hardly 200, or some say less than 200, some say less than 300 Jarawas are left. These are tribals. They maintain their own identity, distinctiveness. They're not like us. They're not backward. They're different. Their education system is different. They eat the leaves. They wear leaves. And some of them are naked as well. They don't wear anything. And that is how, if you watch that movie PK, where Anushka Sharma is telling Amir Khan, asking Amir Khan, are you always nude at your planet? Does it not feel odd? Amir Khan points out to a bird who was just there, saying, this bird is naked. Does it feel odd? But if this bird starts wearing coats, blazers, and t-shirts, it would sound odd. The natural tendency is to remain the way we are, the way we are born. And that's the tribal culture in Jarawas. But people from outside would go and tease them. People from outside would go and would make videos of them, threaten them, and they also feel threatened by the outsiders. To protect the interests of these scheduled tribes, the government said entry of others into Jarawa area is banned. Can you go to the court? My lord, my fundamental right has been violated. What right? Right of movement. I can move freely throughout the territory of India. Where do you want to go? I want to go to a tribal area, which is the Jarawas. Said, no, you can't go there because in the interest of the scheduled tribes, your movement there has been restricted. You want to visit Sentinelese, that also can be restricted. So in the interest of the scheduled tribes, your right of movement can be restricted. This right of movement has two dimensions, internal and external. That means movement within the territory of India, movement outside the territory of India, which means the right to travel abroad. This right to travel abroad comes under Article 21 of the Constitution. So Article 19(1)(d), which talks about right to movement, talks about internal movement. That means you can move freely throughout the territory of India. If you have to move out, that comes under Article 21 of the Constitution. Article 19(1)(e), right of residence, you can reside and settle anywhere within the territory of India. But again, this fundamental right comes with the same set of restrictions in the interest of general public for the protection of the interests of the scheduled tribes. Which means there are some scheduled tribes where there are some scheduled areas where you can't reside and settle. That's why we discuss Citizenship Amendment Act also, where all those who are to be granted citizenship, they will not be made to reside in the scheduled areas of the sixth schedule of the Constitution, of the scheduled areas of Assam, Meghalaya, Mizoram, and Tripura. Similarly, in the interest of the general public, your right to residence can be restricted. If you are suffering from leprosy, separate colonies may be created for you. You can't reside with the others. Can you claim that my right of residence has been violated because I want to live in this colony, but the government is forcing me to live in the leprosy colony? No. Why? Because it is in the interest of the general public. Otherwise, you will spread it. Article 19(1)(f), right to property. It was basically the right to acquire property, right to dispose of property. That was repealed, deleted by the 44th Constitutional Amendment Act 1978. And I will tell you on when we will discuss DPSPs why this right was deleted. One slide. P. Arumugan versus State of Madras. Restrictions of residence on habitual offenders have been upheld as imposing reasonable restrictions. I gave you the example of habitual offender, those who become habituated to committing these offenses, and then they are excommunicated, they are thrown out, that don't come back for 2 years. For example, once Amit Shah was expelled from Gujarat, asked not to come back to Gujarat for a few years. Can it happen? Can these habitual offenders, can the restrictions on their right of residence be imposed? Yes. And Supreme Court said it's a reasonable restriction. The final fundamental right under Article 19 is 19(1)(g), right of trade and occupation. All the citizens in India, they have the right to practice any profession or to carry on any occupation or trade or business. That means all the citizens that we have, you can take up any profession, your call. Any trade, your call. Any business, your call. Any occupation, your call. But can it always be your call? Is it uncontrolled? No. There are restrictions here as well. What are the restrictions? I start selling narcotic drugs, psychotropic substances. The police is arresting me. How can you sell this? Why? Have you not read Article 19(1)(g) of the Constitution? What is that? The police, they don't know. Sir, what? I have the right to carry on any trade, any occupation, any business. And my trade, my business is I want to sell narcotic drugs. How can you stop me? Let's stop. In the interest of general public, we can impose restrictions on your right to choose any trade, occupation, or business. Because it is not in the interest of the general public that you start making them drug addicts. You start supplying them psychotropic substances. So in the interest of the general public, there can be restriction on your fundamental right. Or morning 6 o'clock till 9:30, I am a professor at Byju's teaching Indian polity. Then I go to Christian Medical College, Vellore. So make way for me. Where are you going? I'm going to the operation theater. What are you doing? I'm going to do a surgery, perform a surgery. How can you do that? Why? I have the fundamental right to take any trade, any occupation, any profession. In the morning, I'm a professor. Till the afternoon now, I'm a doctor. After that, where will you go? I will go to the Supreme Court. I will argue a case. After that, I will construct a bridge. I will become a civil engineer. No, my dear, you can't do that. Because professional or technical qualifications can be imposed. You have the right to take up any profession. But if you want to become a doctor, for that, you have to do MBBS course. If you want to become an engineer, do any course. You will still become a software engineer. So whether you are an engineer from metallurgy, graduate in chemical engineering or mechanical engineering or any engineering, you're still a coder. You still code, write the code. But be that as it may, technical qualifications, professional qualifications can be imposed. But you have the right to take up any profession. Nobody can stop you from becoming a doctor or an engineer or a lawyer. Third, state can carry on any trade or business to the exclusion of private citizens, either wholly or partially. I also want a business where I want to develop a nuclear bomb or a hydrogen bomb. No, in this atomic energy matter, you can't take up any business because this government has kept entirely to itself. It can exclude private citizens. Don't come here. Don't take up this trade or occupation, either completely or partially. Railways you can indulge, but other aspect of the railways you cannot. So there are some activities, there are some trade or businesses which the state can exclude you from participating in, either completely or partially. That is Article 19(1)(g) of the Constitution. And that completes our discussion on Article 19. We'll meet tomorrow, 6 o'clock in the morning. We'll discuss Article 20, Article 21, Article 22. Then we will discuss previous year's question papers as well. Since it is Friday tomorrow, is it? Okay. Sir, won't alcohol be against the interest of the general public like narcotic drugs? But then alcohol is a bigger generator of revenue. Same way cigarettes, injurious to health, but nobody is banning them. Why? Because it generates a lot of revenue to the state. Does right of trade and occupation include prostitution and brothels? Uh, there is no ban on prostitution. Prostitution is legal in India, but there is a ban on brothels. Ban in the sense you can't have organized prostitution like brothels. But that is happening, but that is you're circumventing the law. What is house arrest? Is it against right of movement? House arrest we will discuss in Article 22. Preventive, it's basically preventive detention. Do you have to study all chapters from Lakshmikant? No. I will tell you towards the end what chapters to read and what to skip. Sir, in Israel, India took a stand in support of Israel that is unjust to Hamas. Can citizens of India criticize this? Is this violation of friendly relations? You can criticize this unless and until the government decides that you can't publish this because it violates friendly relations with foreign states. But thankfully, the government is not using it often, criticizing your or restricting your free speech in the interest of friendly relations with foreign states. And there have been articles which have criticized government of India for its outright support to Israel. Although Ministry of External Affairs has not issued a proper statement, but Prime Minister's tweets in support of Israel, that speaks of a different, marked shift in our policy vis-a-vis Palestine. If any foreigner who had received title from foreign can get citizenship of India, can get citizenship of India, yes. Do we need to remember all the cases and judgments? Yes. India-Israel relations relevant for polity, relevant for international relations. Group of people violent the public order in Manipur, violating, is it sedition? But they don't want to overthrow the government. It's a clash between two tribes. So it's a normal act of violence. It's not sedition. Okay, see you tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye bye. Take care.